for prosecution. There were notice was issued and stay was also there, but now the trial court is proceeding with the case. Rate is listed for
When it was dismissed in default?
2023, it was.
March it is dismissed.
It has been filed within limitation, but
That's
now
right. March is dismissed.
March
Now
is
you
over.
have.
Now they are
You give the memo. We'll see.
Only a date.
I'm not assuring, but I'll try.
May mention, my lord. The matter was last registered on May, my lord.
What?
Going-
Bail.
Yes, my going through the allegation, my lord.
Bail will come in series.
No, my lord, urgency, his father died, my lord.
Interim bail.
Yes.
When the father died?
24/8, my lord, just Friday.
When is the 10th day? Take it tomorrow.
My lord, I prefer.
You-
Lost, my lord.
You give the death certificate, everything to.
That I will, Sarpanch letter is there, my lord.
No, death certificate. Sarpanch can write anybody.
I get 24 letter, Mursi.
Give whatever you have, you give it to him so that he can verify.
Yes, my lord.
So tomorrow I'll take it up. If it is today only you supply. Otherwise, tomorrow I'll dismiss
Give
it.
him, my lord.
Hmm.
With me, my lord. Sarpanch.
My lord, 2 CRLMCs and the option number 2, my lord. Says operating as a my lord. This, the trial has to say the evidence.
What is CRLMC cognizance against cognizance? Take it. Yes.
My lord, arising out of same FIR, 2 interim bail, my lord. That it is going to be expired on 38/24. My lord, I pray for extension of
Interim bail granted by
your lordship, my lord.
I have given
This, no, this honorable court.
assignment.
Let it come tomorrow, my lord. 30 से expire करी जाऊँगी. The time data. वो काली.
Then you surrender.
No, my lord, I will pray because it is arising out of main case, that is OW case.
That's right. That's right. But interim.
It has been on 25/6/24. I am in interim bail. From that date.
On what ground?
On ground to arrange money to return it back to the opposite parties. That is the main reason, my lord.
That's right. You could not arrange.
Yes, I arrange something, or I will arrange another.
What have you arranged?
Some direction is there to deposit rupees 5 lakhs more.
How much you have deposited?
50%, my lord. Deposit.
You keep on extending and.
No,
keep on
I'm not.
depositing 1,000?
No, lordship. I'm not asking for extension of time. I'm asking for reliable sources. I'm getting information that I will get money so that I could able to deposit before.
What do you want exactly? You are again extension of time.
Extension of time, my lord.
We'll see.
Let it come tomorrow because 30th is the last.
Tomorrow. You can't come in the last day and pressurize like this.
My lord,
You should
30th.
have come. You know that you could not do it.
30th.
I see. It is not possible. Try to understand. how
Day
can
after
matter?
tomorrow, my
Why
lord.
have you not come before?
My lord, that is.
Then
no, that is.
so go and surrender. I'll
No, my lord.
you show your bona fide by surrender.
My lord, let it come day after tomorrow, my lord.
Right.
My
You surrender. You show your bona fide. I'll give you entry pay. Let us see. How honest
If
you
your
are.
lordship will grant me time, my lord,
I'll definitely grant you time, but you abide by the first order. You surrender for 1 day and come and I'll extend. So you are bona fide.
My lordship, the matter was listed on 16/80/2020.
Yes, what do you want? Bail.
Bail.
Bail, no mentioning this. It will come in serial.
My lord, bail matter,
It was
Bail matter, please don't mention it. Will come in
80%
serial.
disabled
I
person.
will not
it
give
was
preference
specific
to any bail.
urgent. My lordship.
Only interim and if somebody died or extension and all these things.
My lord, my application is interim bill. My father is serious, surgery is required. Only son again.
Serious also will take care of. Oh,
Day after.
don't fix the date. We will decide ourselves. Give the memos, but I am not assuring you. Only somebody dies, interim bail to be expired, all those kind of thing, I'll take.
My lord,
No question of
questioning of FIR, my lord, matter has been settled between parties, my lord.
what is the offense?
363, my lord.
What is the terms of settlement?
My lord, the son of the informant selling liquor in the local market,
What is the terms of the settlement?
villager. ତାକୁ ଛାଡି ଦେଇଛନ୍ତି ତାକୁ ଧରିକି ନେଇ ପୋଲିସ ଷ୍ଟେସନ ଦେଇଥିଲେ
लगा दो यार कभी बीच में next week.
Honor,
On 22nd, sir, actually, I have praised for today for the CRLMC. That is, Aji sir consider heitila, but list he and so please can it come tomorrow?
Give your memo, we'll see.
Okay.
What can you?
I mean, even for 138, that matter has already been fixed date. That date, unfortunately, court have they function.
Weekly list, final hearing.
Taken up date.
They just see how many bail matters, let us see. We all take it up.
Like, that the small matter.
What happens to the people those who have already retired? I'll just see if I have time, then I'll take it up.
That are not being.
But what to do? Am I doing it deliberately, you in your matter? You see the pressure accordingly. You argue and go, thereafter it is so big for me to give a dictation. And there are cases where I have told the learned counsels to give the period of undergone, they are not giving. They assured that they'll give period of undergone, they have not given. I am keeping on requesting, please ask the lawyer to give it. This is the level of assistance, what to do. I'll do it. Yes. Yeah, yes.
Again, 167 to I have application. That matter is
Give your memo, we'll see what. Nothing, yes.
Pardon to mention, my lord. This is a withdrawal of bail application. My lord. This is not listed in the list, my lord.
Take it today. Take it today.
Pardon to mention, my lord.
Tomorrow. Withdraw.
Pardon to mention, my lord.
That's the best thing I can allow.
Yes. I may be pardoned, Milord.
Yes.
Milord had filed an IA in the matter seeking some urgent directions for preservation of evidence, Milord. This application was filed in July, Milord. That matter had gone back to Honorable Justice A.K. Mahapato's court and has come back to my Lord's court.
You
After
want
the
more there?
no, Milord, I am I'm sad. Milord, may kindly come tomorrow, Milord. My seniors.
Tomorrow, don't tell tomorrow and day after and all this thing. I'll have to adjust the other thing.
It's an urgent application seeking preservation of evidence, Milord, which may
When
be.
have you moved the application?
I have an.
When have you moved the application?
I have filed it in July, Milord.
July.
No.
Till July to today.
I've been running from the registry to the listing to courts, Milord.
And immediately overnight.
It has come before my lords.
Okay,
Now
you give it.
I'm hopeful that it is. Milord.
I too am hopeful.
Milord, may kindly come tomorrow, Milord. My seniors also appear.
I too am hopeful that I can.
I wouldn't have pressed, Milord, if it wasn't this urgent, Milord.
We'll see that.
Pardon to mention.
Check it up if possible Friday, right?
Pardon to mention, my lord. I am for the opposite party in the CLM's application. The matter was last directed to be listed on 12th April, my lord. And there is a stay operating. For last 1 year, the trial is.
Who is for petitioner? Bring it.
I'm mentioned.
Give your memo.
Fine.
May I mention also? The order was of 16th April, Lordship, the 482 application of hypothecated vehicle will be disproportionate in the list, my lord. I mentioned, Lordship had given me and that
And you now you have seen what is happening.
We have filed the hypothecated certificate of the registration of the vehicle, 100% finance vehicle, and Lordship had told me that it will be disposed of because we are not sought any interim protection.
Right.
Charges will be framed, Lordship.
Yes.
Kindly take it up tomorrow. I have already filed all the documents, Lordship.
Can I do it in Monday? You are here, then I'll take it in Monday. Tuesday. Okay. Tuesday I'll take it. Because he has come from outside.
May I please, Lordship? BLPL number 3795/24 এটা Honorable Justice A.K. Mahapatra କୋର୍ଟରେ ୱିକ୍ କମେନ୍ସିଂ 29 ଜୁଲାଇରେ ଆସିବାର ଥିଲା ସ୍ପେଶାଲ ଆଡଜର୍ନମେଣ୍ଟ ଥିଲା ଆସିପାରୁନି କାଇଣ୍ଡଲି ଟିକେ
Bail matter, I'm not going to give preference, it will come serially. And your matter will also be taken up. Don't worry. Give the memo, we'll see.
I beg your pardon to mention, my lords.
Yes.
I beg your pardon to mention, my lords.
Yes.
My lords, please don't mistaken me, but I'm in a very troublesome situation. I know your lordship has made it clear that bail matters will come serial wise, but I'm constrained to make this submission, my lords. It is with respect to bail application number 5616 of 2024, my lords. It is, the petitioner is a 60 years old and above, my lords. He's a 60 years old man, my lords. He's languishing custody since January 2024, my lords. Now it
What
was
is the offense?
offense
What is the offense?
302, my lords. 302,
Not
302. I know the offense is grave, my lords. I'm not disputing it, but it was placed before His Lordship Justice A.K. Mahapatra and was last heard on 27th of June 2024. Thereafter, it was directed to be listed for order.
Definitely, your matter will be taken up out. You please give your number. I'll see that your matter is.
5616 of 2000. Now it is destined to place listed
Where
before
do
the
you have
lordship.
any instructing counsel here around in the court?
No. I'm from Sambalpur, my lords. I do my submission
You
virtually.
Repeat your number once again.
5616 of 2024.
5616.
Yes, my lords, of 2024.
23.
2024.
24.
5616. Any date, my lords.
We have
This
noted.
week.
We'll do that. Okay.
Much
Thank you.
obliged, my lords. Much
Thank you.
obliged.
I may be pardoned to make a mention, my lord. My lord, I may be pardoned to make a mention.
Possible. Let it come. Let it come. Yes.
Beg your lordship's pardon.
I may
The
be
matter is
pardoned to make a mention, my lord.
fixed for 12th of this month, my lord. Not listed. NBW issued against the petition. Maybe any time.
Cancel is available. What do you want? Cancel.
Stay of NBW.
Cancellation and bid लगा दो.
Pardon to make a mention, my lord. My lord, item number 107. As per noting, withdrawal memo also there. Permitted to it.
110.
Oh, bless you.
Maybe
Lordship,
excuse my lord.
item number 42. Lordship, call it some other date.
42.
42, right?
42.
I may be-
I think you are watching the mood of the court too.
No, everyone's there. She's there. She's also there.
Okay.
Pardon to mention, my
3
lord.
weeks after minutes.
Pardon to mention, my lord. Item 122. There are
42
three,
adjourn करो.
my lord, item number 122. There are three cases, my lord. The further adjournment mediation further date is 6/9/2024.
Awaiting mediation report adjourn.
I may be pardoned, my lord.
Madam, 120, madam. Next week, madam. 126,
Yes.
next week, madam.
126. Let us see. It will be go to the next week only. We don't know whether we can reach or not.
I may be excused, my lord.
Adjourn. Adjourn.
My lord, I may be excused to make a mention, my lord.
Yes, madam.
My lord, there is a CRLMC number 1605 of 2023, which has been specifically adjourned to 22nd of August by your lordship. But somehow it has not come on the list, and
It's all right. You give the number. Let us
my lord,
start.
secondary achi tola court re.
Yes. You give the number. We'll see it. Okay.
My
Yes, sir.
Item 110. It was being fixed to 2 p.m. But 2-3 times my friend Mr. Maharana has some genuine difficulty. So I want that 2 p.m. noting should be there on the next day.
Give a date and see.
Se 110
10 and 11 both. Give it. Give it. Okay. But 2 p.m. that noting will be there.
Oh, bless.
Yes, Mr. You may, if you have any other matter, if you have
that is 117 131 ଆଉ ତିନି କରିଦେଇ ପଳେଇ ପାରିବି କିନ୍ତୁ 117 131 ସେଟା ବି ଆସିନି instruction
while going you tell.
yes
Yes. Let us start. Start from 39. Yes.
39.
Yes,
It is
madam.
your lordships.
Yes, madam.
The petitioner is assailing the order dated 36/2020.
Huh? Without sight.
It is a bad start for the dates.
Physical is there. His files are not opening. Yes.
My lords,
Yes, madam.
I'm challenging the order of cognizance dated 36/2020, your lordships, which your lordship will find at Annex 2, page 13.
Yes.
Your lordship, the fact is like this. The informant lodged an FIR, Annex 1, under section 380 only. That is theft from a dwelling house.
Yes.
And that is like that I have left the house keys with my neighbor, the present petitioner. And the milkman came and he saw that my house was locked. So he gave my milk at 1 p.m. of the day to my neighbor. And when I came, my neighbor came to my house and said that you were not there at home, you were upstairs. So I have, the milkman had delivered the milk to my place, your milk at my place. So I'm returning, giving you the same. But when the informant entered the bedroom, he found that his almirah was open and everything looted out. It was clean. Now,
The door was broken or was it open or what?
that part is not there anywhere. That
What is the
FI
investigation?
Whenever the informant and his wife and the son, my lord, there are 3 persons residing in my house, my lord. Next door neighbor is the petitioner, my lord. Whenever they,
You are employing presumption.
Then I'm going there, your lordships. I'm going there.
whenever they went to my lord,
You
their
jump
office or any other work, my lord, they used to keep the key of the house.
Right, never
going there.
unnecessary.
I'm going there, your lordship. So that was the initial FI.
Have you included informant?
My lords, informant.
Informant issue notice.
It's a complaint.
Include it. I'll see that it is.
I'll implement it by hand or lordships?
By hand you do it, issue notice.
Lordships.
And returnable 1 week for it.
Lordships.
I'll settle it.
Lordships. The other fact is that the trial court is proceeding.
You move an
And
application.
there was an interim order already that I will move an application accordingly. That will
Same.
be extended.
Same.
Oblige, Lord.
Yes. Now you do it, issue notice to the opposite. Yes. Yes. Next.
40.
Yes. Very slow. Today, the board will move very slow, it seems, because this is. Yes.
Not there. 457 application, my lord, that has been allowed. But 457 application filed the petitioner, my lord, that has been allowed with certain condition, my lord. They did not fulfill the condition, my lord. Thereafter, my lord, the
So non-ABS for the petitioner in the interest of justice adjourned. Yes. Next.
41.
41. Yes. What is this?
In this case, my lord, pray for my lord the pass the order dated, my lord, 29/4/2023, my lord.
29/4?
29/4/23.
What is this? No, 22/12/2022.
Arrangement of 1/6 case.
CC case. There is an FIR. Non-ABS for the petitioner in the interest of justice adjourned. Yes. क्या हो रहा है guys? What is happening in the other court?
Item 40, there are 2 cases, my lord. For that, we may have entered around. That both
Giving
cases.
it both the cases.
43.
Today it's see the server is down. It's very difficult to now. Yes.
May I please, your lordship, here I have challenged the order of cognizance taken under section 7A2B of the Factories Act, my lord.
Yes.
And that section, particular section is not in punishment section, it is in definition section. 7A2B, my lord.
Cognizance is taken.
Yes, my
Are you
lord.
on charge? Why do you worry? Charge has not been wrong. It's good for you that yes is taken. You should be. Why have you come? Inviting problem for yourself.
Well, because it is cognizance has taken against the chief boss of the factory.
That's right, but see, if wrong provisions, cognizance is taken, wait till the charge is framed. Withdraw it and argue on charge.
Well, that will be a problem, my lord.
What?
Well, later, the factory act people maybe summon, my lord, because kindly have a glance to the 7A2B, my lord. It is the general duties of the occupier under the Factory Act. Duty.
Whether gym is a factory or not, have you got some material?
Yes, that is. I have filed also their complaint petition.
Complaint petition. No, gym is whether gym can be categorized as a factory.
Is it a factory?
You are the occupier then?
I am the occupier.
Then
I have to do certain duty under the section 7A2B. And it is not a punishment section, it is a definition section.
That's right, no problem. Why do you worry about it?
With that objection, my lord,
Learned counsel for the petition, in this petition is seeking quashing of order dated.
Order dated, my lord, it is
25/3/2019. Passed by?
SDGM Sambalpur.
Which annexure?
Annexure 2, page 17, my lord.
By learned STJM. Where is that? Which page?
17, page 17.
7.
25/3/19, second order, my lord.
Yes. Twenty-five.
3/2019. Page 17, second order.
What's that? SDGM, huh? This is also whereby whereby cognizance of offence under section 7, capital A, bracket 2, bracket 6, bracket B, na?
So 7A 2B.
7A 2B of Factories Act is taken against the petitioner. The land counsel for the petitioner submits that section 7A to B is
definitions,
and therefore the cognizance ought not to have been taken in that provision. Be that as it may, since the matter is at the cognizance stage, I am not inclined to interfere with this matter. However, liberty is granted to the petitioner to raise this point at the time of framing of charges. If such, if the trial court shall deal with the said point at the time of framing of charges. Yes. Next.
44.
44, my lord. The release of the seized article, my lord. The petitioner is a politician who has lost the last 3 general election from the Redakol constituency and the Congress party. On 2000.
You are challenging cognizance?
No, my lord.
Quashing?
Not quashing. They have seized my revolver, licensed revolver. They are not. I have filed a petition before the learned court below. Court below rejected it.
You are not accused.
I am accused.
Yeah.
Accused. It is what has happened, my lord. On 11/2/2022, a affair was basing on a newspaper article published on 6/2/2022. Basing on that, my lord,
my lord, judgment, my lord, the rejected, my lord, on 26/8/2023, my lord. On the ground, my lord, by the time when the revision filed before the sessions court, my lord, by the time the reversal in question, my lord, sent to the my lord, the
RFSL.
RFSL.
Then it was in RFSL.
Now my lord, till date, my instruction is that it is still with the RFSL, my lord, there. Neither there.
It needs to be examined as it takes time. What to do? It's a part of investigation.
Part of investigation. Charge sheet has already been filed, my lord.
That's right. It is still there. After they receive back the weapon, you move application and get it. Why are you? What will you do? I want to kill someone. What?
My lord, already one and a half.
What will you do with the weapon?
Sorry, my lord.
What will you do with the weapon so urgently?
It is
Let it be there.
It is my license revolver, my lord, costing more than.
It is so urgent for you.
Because I am staying my farmhouse inside the forest.
Who?
In the Mawadi area.
You are an accused in such a heinous crime.
No, not heinous crime, my lord. It is under section 341, 307, 506 and Arms Act only, my lord.
All right. Where is that order? Impugn order?
Order is at page, my lord. Page 30, annexure 3.
Revisional code order.
Revisional code order.
Where the court says that it is in
the
paragraph 7.
7.
Paragraph 7.
6th line from the border. The said revolver has not been received back till yet.
Right. Petitioner is agreed by the order dated 26/8/2023, passed by the Special Judge Vigilance, Sambalpur. Additional Sessions Judge come Special Judge Vigilance, Sambalpur, in criminal revision number 6 of 2006/1 of 2023, whereby his application under section 397 CRPC, his application
for release under 457
CRPC, which was turned down by the trial court.
JMFC
City
Sambalpur. JMFC to City Sambalpur.
City Sambalpur has been confirmed in the revision. Has been confirmed. The revisional court in para 7 has inter alia stated as under para 7 page 35. Since the rejection is only on the basis of that the revolver in question has been sent to RFSL and for ballistic examination, and it has not been returned to the investigating agency as yet. Although the charge sheet has been filed, the release could not be directed. Therefore, I'm not inclined to interfere in this matter. However, liberty is granted to the petitioner to
That liberty already went there, my lord.
renew his application under 350, 457 KRPC after the investigating agency receives back the
Seized revolver.
Seized revolver
As well as the expert opinion.
from the
RFSL Sambalpur.
This liberty the petitioner is disposed of. Yes.
45, item 45, I have filed this application of passing of the proceeding on the ground of compromise. The parties are not coming, my lord, now. I pray not press the same with liberty to.
The petitioner seeks to withdraw the present petition to revive his prayer for passing of the FIR if the cause still survives. So he submits that since the petition was filed for passing for the FIR on the ground of settlement and the parties are not coming forth to appear before this court, he is making such prayer. With this liberty, the petition is disposed of. Yes.
46.
Yes. Yes.
Order also fee on internal page 22, that is 611 to 43.
Yes. What do you?
I want to cross-examine the victim also.
Cross-examine?
The victim also. He has not been cross-examined.
Victim?
Yes. She appeared in also with court, say, engagement directly the earlier date, he has court, he has to appear.
376?
Yes, sir.
POXO is not there.
POXO is also there.
Opportunity once given,
Yes, that's
but
fine,
so he has not turned off. Again, my lord, the
not turned off, also. On the date that also, so far the senior counsel is concerned, he was in other station, he could not able to reach by time. So the
Where is your application under 311?
There you go.
Where is that?
Okay,
Where is that? What are the questionnaires? You have not cross-examined at all.
Sir, glance, he has not been cross-examined at all, you not see.
Where is that? Where is that?
6/11/2023 hours.
Yes.
The record has been.
Defense counsel of
posted
victim
to
and victim is called
cross-examination in view of the order of interest for the accused is absent and allowed to be represented.
Where is that adjournment application? Show me. Show me what are the grounds of adjournment?
order number 44, 16/8/2023, my lord.
Show me the ground.
Allowed, my lord. Subsequently, he has not, the advocate not present for that reason, my lord. And law is also.
Subject to the adjournment.
Again and again, my lord.
Without defense counsel has asked for adjournment without assigning any reasons as to why the hearing should be adjourned to the later date.
Find that time petition and all.
You can't take a trial, so casually. Taking into consideration the submission advanced by the petitioner without assigning any reason, the petition of adjournment is rejected.
Was there. Simplified an adjournment application.
How much cost?
300 my lord cost.
No, I'll impose cost 5,000. And
500.
No. I will give only one chance. 5,000. Nothing. The petitioner's application for adjournment moved before the trial court has been rejected by the order dated 6/11/2023. The witness was the PW. PW, which PW?
PW 1.
PW 1.
PW 1.
Sure.
My lord.
Victim informant present and she was examined. And she 16/8/2023, she was examined. And you are taking everything,
300 rupees court imposed, then another date given 16/11, my lord. But the council not present.
We paid 300 rupees, but the council engaging was not.
Maybe you can't take, see, I see the proceedings. I will not allow. I'm sorry. 16/8/2023, she was examined. Thereafter, on 19/8/2023, took time. 28/8/2023, took time. How many? 1, 2, 3,
1980 P was not there, Lords. P was not there.
4, 5 days.
1980 P was not there. This is the order, Lord.
That is not just for.
And 2880 also P was not there. And 18 is P was not there, Lord.
The witness, PW1, was sought to be cross-examined, and however, sought to be cross-examined on the date fixed. However, the petitioner moved in an adjournment application without assigning any reason. Let counsel for the Mr. General and counsel for the petitioner submit that on that day the senior counsel was supposed to cross-examine the witness was not available. It is seen from the record that on 16/8/2023, the said witness was examined, and the matter was subsequently adjourned to time for cross-examination of the said witness. Eventually, on 6/11/2023, when the matter was fixed for cross-examination, the petitioner sought adjournment, short adjournment by moving an application, and the said application was turned down. Therefore, the petitioner agreed. Since the petitioner, being the accused, being an accused, has the indefensible right to defend himself, he has a right to cross-examine the vital witness. Therefore, I am inclined to allow the application. However, taking into consideration the conduct of the petitioner, the application, the present petition is to be allowed, subject to the petitioner paying a cost of rupees 5,000. To the 5,000, I'll increase. I otherwise I'll reject it. Tell me. I'll reject it. I'll tell you, don't do it. The conduct don't do it. 5,000 rupees to be paid to the witness. PW1. It is made clear that the petitioner shall be afforded a single opportunity to cross-examine the witness. The date will be fixed by the trial court, and under no circumstances the petitioner shall seek adjournment. If the petitioner avoids to cross-examine the said witness, the right to cross-examine the PW1 shall stand closed. Huh? So adjourn. Yes, next. 47.
I'm ready to argue this case.
You didn't come, then what? Next. Yes.
May I please, your lordship?
Yes, sir.
In this first, no.
We'll see which it is.
47, your lordship.
Yes. Next.
The present petitioner is challenging the order taking cognizance under annexure 3, your lordship, running page 26.
Annexure 3.
Annexure 3.
Yes.
Running page 2630.
Yes, sir.
The learned magistrate has taken cognizance under section 370A and 345 of Immoral Traffic Act, your lordship. The prosecution allegation, as per the prosecution case, filed that on 28/8.
Annexure 3, which page?
Annexure 3, running page 26 to 30.
26.
Yes.
Okay. Yes.
In this case, your lordship, the prosecution case is that after getting reliable information, the informant with the police officer and other staffs make raid the Sonali guest house, your lordship. And in the Sonali guest house, 2 people, that is Puja Sahu and Sonali Mahapatra, detected there, and the FIR has been registered against the other two accused person, that is Arjuna Sahu, who is the person who is detained in that Sonali guest house, who is not the present petitioner. And the manager of the guest house, that is Padma Charana Panda, who is not the present petitioner.
Who are you?
Are
you arguing for the persons, those who are not petitioner?
No, no.
You talk about you.
Yes, sir. In this case, my role is, as per the prosecution case, is that I have procured that two ladies, the major ladies, in that guest house. That is the allegation against me.
Yes.
Now the important is
you are not.
No.
Then that you have to prove it in the trial.
Yes, yes. No. In this case, Your Lordship, whenever the prosecution collected the materials, that should be admissible evidences against the present petitioner. The Puja Sahu, Your Lordship has directed
So the girls, where are the statements of the girls?
Yes, Your Lordship may see the order dated 13/2024.
No, show me the statement of
no, that is important. The 161 statement has not been recorded in the by the IO in this case. Then the direct evidence should be procured from that two ladies. And when there is the statement, their statement has
recorded 161.
No, my lord, what happened in this case, my lord? Though that two my lord lady, they have shown as a chassis to witness of 10 and 11, my lord. But in fact, my lord, I had gone through the case diary, my lord. Though the case of 2016, and what happened in this case, my lord, the IO examined both the lady, my lord. They have stated that examining her, she stated that on 27/8/2006, she along with Oja Sahu had been brought to the Sonali guest house, district center, CS Chandrasekhar BBSR by one Rabindra, this petitioner. Rabindra
the statement is there.
And his friend Rakesh for an interview, meeting for one job, which Rabindra Tarai has arranged for them. She declined to decline of the allegation of having sex with any other person. Both of them, they have stated.
That is the
But in fact, they are they are found in the guest house, and
that I am not on that. Whether they were apprehended, these girls were apprehended in a guest house, and the allegation is, and the girls are also saying that this gentleman, Rabindra Tarai, had brought them, saying that there is an interview.
To the said guest
house.
Right.
Submission, Your Lordship. Have directed on 13/5/2024 to obtain the 161 statement of the present victim persons. Those victim persons, the IO apprehended that victim persons, sent them for medical examination, seized from them the material collected from them, and they have not recorded the previous statement, 161 statement. Whenever there is no separate statement recorded by the IO and the CCTV footage,
Where is the charge sheet?
Yes, charge sheet. Running page 1725 under annexure 2, Your Lordship.
It is 370 capital A.
Yes. That is the 370A. And at least Your Lordship should kindly see, there is the Innova car has been seized from the Arjun Shah, who is the accused, charged accused person. And a register has been seized from the manager, who is also the accused. And the CC camera also collected. And nowhere, no material admissible evidence that the presence of the present petition is not there. Only hearsay witnesses, all witnesses, stereotype witnesses.
Sir, all these things will be tested at the right stage. Not the cognizance has been taken rightly.
When 161 statement, समस्त कहते हैं, हमें सुनिलु, पूजा साहू और सोनाली महापात्र पाखुरु, जे तराई ताकू नेकी आस्तिला.
You move an application for discharge and take all these points. Cognizance order is correct.
Your Lordship will.
I'll give that liberty to you.
Kindly.
You extensively argue these points. Cognizance order, this is enough.
The Karnataka High Court and Kerala, Andhra Pradesh High Court, Your Lordship have passed. My case is better than that case, Your Lordship.
I passed this order, I know that.
In that case, Your Lordship.
They are the customer.
That is customer. I am the better footing than them. Whenever there is no direct evidence.
Procurement. See, the evidence says that you have brought them, saying that there is an interview to the Sonali guest house, where they it's kind of they're running a brothel kind of thing.
No, that is the.
And in this case, I have quashed it because these are the customers. They have no clue.
No, in this
they have not procured the girls. I have said that the cases against them under immoral, it will go on. But 370 is not made out against them. That's what I said.
Yes, I will satisfy your lordship. My lord and friend has submitted that there is evidence that the case diary which cannot be used during the trial, that when there is no separate statement and a previous statement of the Puja Sahu and Sonali Mahapatra, what is to be, if it, in the conclusion, if all the prosecution witness has been proved, has been placed before the trial court, and the petitioner cannot convict basing upon the hearsay witness. All stereotype the 161 statement has said.
I am not convicting, acquitting you otherwise. All these things
My
you can
humble-
argue, you know.
My humble submission is lordship.
You move application for discharge. I am giving that you. I will not say anything. You simply withdraw, move an application under right provision for discharge.
At best, if you consider the all materials which is available, whether it is admissible or not admissible, I may be at best attracted for procurement.
That is precisely I'm
Yeah.
saying that, Mr. Vishwal, that is precisely I'm saying, whether a particular offense is made out or not, at the charge stage, you can argue all these things. And if you insist for me, then I'll simply say that professor case is made out, then it will prejudice you in at the stage of court trial. So I'll record your statement. Better you move appropriate application for discharge. If I believe you should be discharged. If nothing happens, then you can have the right to come to court.
My submission will be recorded that there is no 161 statement recorded by
Right, yes. In this petition, the petitioner is challenging the order dated 14/3/2022, passed by the which court 2026, no? Passed by the SDJM Mishra, whereby cognizance of offense punishable under section
cognizance
300.
Just
370A surplus 2, read section of 3457 of ITP Act. 370A to IPC and read section.
Read which section?
ITP Act.
ITP Act has been taken against the petitioner and other accused person. Mr. Vishwal, the counsel for the petitioner, submits that the cease of his involvement ought to have been the petitioner. There is no direct evidence. Submits that there is no direct evidence collected by the prosecution to implicate the petitioner in the case. Even the girls, those who have been who alleged to have been procured by him, their statement has also been not recorded.
Separate 161 not
Separate 161.
but stated in the case diary.
But separately under 161, their statement under 161 CRPC has not been recorded. The prosecution is relying upon the case diary entries. So on that basis, the cognizance ought not to have been taken. Mr. Vishwal further submits that even if the allegation made against the petitioner in the charge sheet is taken at face value, the offences for which the cognizance has been taken shall not stand the scrutiny of law. I am not inclined to entertain this petition at this stage of cognizance. However, the petitioner may move appropriate application before the court below, seeking discharge on the grounds as urged by him in the present petition. If he moves such application, the same shall be considered on its merit. With this observation, the petitioner is
Added matter, both the victims cited as a charge sheet witnesses were 10 and 11.
Mr. Ragda and the per contra submits that although separately 161 statement of the victim girls have not been recorded separately, barring the case diary entries, but they have been cited as witnesses in the charge sheet.
I have two claims that I may be, if your lordship think it, that they have refused to be examined in the medical exam. They have refused.
that may be.
Mr. Vishal further, the ऊपर लिख दो, Mr. Vishal further submits that the girls have also refused to submit to the medical examination. Medical, yes. 48.
My lord, the petitioner is the informant and the old man of 70 years, my lord. Due to.
Yes. What are you challenging,
My
sir?
lord, challenging the order under Annexure 5
Hmm.
dated 18/2000 passed by Lord JMSU regarding recall of the witness, my lord. Issue on where the Lord court will issue notice to the informant. Informant is the present petitioner.
What is the offense?
My lord, offense is under section 294/506 is 55110.
Who is the PW?
My lord, is
One.
the in the
Where is the application? 311 application. Show
My-
me. Show me 300.
My lord, application is under Annexure 4, my lord.
My lord, can't see that his prayer, my lord. Therefore, graciously pleased to admit the application, call for the records and hearing the parties to quash the impugned order, Annexure 5,
My lord.
to drop the criminal proceeding.
My lord. My lord, kindly see. My
What do
lord,
you want?
in
A 311 application, proceeding will be dropped.
my lord, in the 311 filed by the one of the co-accused, my lord. And my deposition is at page 3, my lord.
What
In
do you
its
want,
part-
sir? You tell me what is your petition?
My lord.
Have you moved an application on 311 which was rejected or
No,
not?
no.
Then?
The accused, co-accused has filed a petitioner in his deposition made deposition that I do not want to further in this case. The matter is compromised between the co-accused persons. Between the informant and the co-accused person, my lord.
Proceeding.
Who are you? You are the accused.
I am the informant, my lord. Informant is a senior citizen. My lord, kindly see page 20, para 3.
In
At
which
present,
age-
my lord, in similar case, my lord.
You have created the same problem in another matter also.
My lord, similar order.
Same. I have passed that order.
My lord.
You give some impression, get some order, and thereafter you baked out and all these things you have done.
My lord, kindly say similar.
Why should I interfere in this?
My lord, the petitioner is a old chronic diabetes.
Maybe who are you? You are the complainant.
My lord.
Why are you keen to? You have initiated a proceeding. Why are you keen to getting it dropped? Let the accused come.
My lord, accused, there are several accused persons, my lord.
Let them face it. You are the informant. Why are you so keen to drop? You have initiated the proceeding. Now you want to drop it.
My lord, notice may be issued.
Now, why should I issue notice? Let the accused come. How are you aggrieved?
My lord,
It is a police case. Police has investigated, filed the charge sheet. Police is prosecuting. Why are you keen?
My lord, there are 5 actions.
Let it be 1,000. How does it make difference?
Only one accused person has filed the 311 petition, my lord.
How does it make difference? You are the informant. You don't go to the court. Prosecutor is doing your job. If the accused persons are aggrieved, they will come.
My lord, I have made my deposition, my lord. I do not want to.
How are you?
On where I.
Let it be. Will you withdraw or I'll impose cost? Cost of at least 50,000 rupees because you have already done one matter. So therefore, I'm saying, what is this? The informant.
My lord, informant.
And accused move an application under 311.
70 years old.
That was rejected. You being an informant, you are coming to this court.
My lord, fact is, my lord, the petitioner is having 2 farmhouse, my lord. My lord, the accused person has always creating problem and theft all the.
Then why have you filed the complaint then?
My lord, they have
Shall I record it? Shall I record it? I'll call these. That means the accused persons are threatening you. That's what you are saying. I'll take them to task.
My lord, thereafter the matter has been all compromised.
No, it is something hidden agenda.
My lord, notice may be issued to the
I will not.
accused persons,
Right.
my lord.
Right.
All there are several accused
No.
persons, man.
The petitioner is seeking quashing of the order dated. Where is that order dated? Order
My
dated
lord,
18/1/2024, whereby the application moved by one of the first petitioner is the informant in the present case. He is making a grievance against the order dated 18/1/2024 passed by the JMFC Bhubaneswar in GR case number 490 of 2018, whereby application moved by one of the accused under section 311 CRPC has been rejected.
Allowed.
Allowed. Sorry. It is surprising that the prosecution is not aggrieved in this case, whereas the complainant is moving an application for quashing of the same, and on the basis of the said grievance, the petitioner is also seeking
My lord,
dropping of the entire proceeding initiated by him against 5 accused persons. According to this court, the petitioner grievances are unfounded. If at all, any relevant, if at all, anybody, any agreed person approaches the court, the matter could be entertained. Since the petitioner is devoid of merit, the same is dismissed. Yes. Next. 49. You can't do that. You have
My
already
lord, the
done in one
petitioner-
matter.
My lord, the petitioner is a old person, 70 years, and suffering from heart and cancer, my lord.
So then,
Therefore, he does not want to proceed to go to the court.
he need not go because prosecutor is there for you. Prosecutor is there for you. Under 301, you need not go. Are you going and facing the trial? Are you facing the trial? You are the informant. You are not facing the trial.
My lord,
Accused are facing trial. Let them come forward. Then you give consent. Yes.
Earlier also they came to this court, my lord. This court directed for expedited the trial, my lord.
You see, all these kind of things, these are mischievous petitions.
23 to 21.
Yes. Next.
Another CRLC.
49 can take a warning after.
Yes, adjourn. On request. Yes.
50.
Yes. 1CC case. Last time also none appeared. इसको pass over करो. If the afternoon nobody comes, then we'll dismiss. Okay. याद करा देना. ठीक.
51.
May I please draw?
Yes, sir.
My lord, the present petitioner filed this application, my lord, on basis of compromise, my lord, in between the information.
What are the offences, sir?
My lord, offense under section 341, 324, 307 of Indian Penal Code.
Have you included?
My lord, I have included the injured and as well as informant, my lord. My lord, he also present in the before your lordship. The present informant and opposite parties.
Let us see what are the injuries.
My lord.
Injuries, medical report.
Fine.
Victim is there, appearing.
My lord,
Accused,
my lord, this one is accused.
Just see which part of the body.
My lord, it's the neck portion, my lord, injured, and now the matter has been settled, my lord.
Maybe settled, but 307. What are the weapon?
My lord, knife, my lord.
Yes, Mr. Raghunath, just see.
My lord.
Knife injury, simple or grievous?
My lord, the injury is grievous, lord.
Grievous,
my lord.
Injury is grievous. And there are, my lord,
village dispute, my lord. They are, my lord, residing together, my lord. Peacefully, my lord.
Mr. Raghunath, you have to see this. You place it on record because
My lord, I have given my lord already.
You file it here.
My
If the petitioner seeks to file additional document to substantiate the case, the petitioner is seeking quashing of the FIR number so and so under section so and so on the ground that they have settled the dispute with the victim, injured, and the informant. So and so appears for the injured victim and informant. The petitioner as well as the informant victims are also present in the court. Letter counsel for the petitioner seeks to place on record the medical document and other relevant evidence. This is the matter. Investigation charge sheet is filed.
My lord, charge sheet already
What is the
filed.
stage?
My lord, charge sheet
Only
was-
charge sheet. Cognizance has been taken.
Cognizance already taken.
Charge has not been framed.
My lord, charge already framed. My lord, the case is proceeding before the pending of the sessions, assistant says,
What is the
SCJM.
stage of
My lord, trial is commencing, my lord.
commenced or commencing?
My lord, the Sakhi, my lord, the trial is, my lord, commence, my lord. I the instruction from the.
Then let the victim go and appear before court.
My lord, the matter has been.
No, 307, a knife, grievous injury.
My lord.
482, how can I
The
do it?
interest of justice, lordship may.
Interest of justice doesn't mean that in heinous crime I keep on
My
watching
lord,
like.
due to manner,
So you place it on record. We'll see.
My
Place it on record. Place it. We'll see. 52.
52 minutes. There is two application minutes. It is based on compromise minutes.
In
Father
that
and
case,
son.
recovery has taken place. Knife recovered. Huh?
Knife recovered, though I have not received the case there, but she had given the charge sheet and injury code with me.
Just check it out. What are the kind of evidence?
Just I had given the.
Okay. Yes.
Well, in this case, Millards, compromises may help Millards. And Millards, there is two application. Another Millards is 2594 Millards. It was earlier had and order was passed by the Honorable Court number 2 Millards. To tagged both the cases and listed before this last week Millards.
I didn't follow you.
Millards, two applications there. One is father, another is son. And this application relating to son Millards. And another application is 2599 of 2024 Millards, pending Millards. And order has been passed.
Please this matter along with the other one. Give the name.
My lord.
Please give it. Yes. 53.
It's a matrimonial matter, Milord.
Tag code. Tag. Yes.
Matrimonial
Yes,
matter,
sir.
Milord.
Yes.
Offense under section 498A and 506, Milord.
Yes.
The parties have compromised, Milord.
Bring them, I'll pass. Bring them. When? Tomorrow, day after, Monday, whenever you want. Matrimonial issue, I'll pass it then without seeing anything.
Divorce allowed.
Huh?
Some divorce allowed.
Whatever, allowed or no allowed.
Permanent element.
No question of it. Shall I issue notice then? Okay, issue notice. Notice to opposite party number 2, written within a week. File the requisites and bring them. Let them appear with
Yes,
you. Okay. Good a week chhadi ki rakh diyo so that take it. Yeah. 54. Is there any? They are on bail and all?
Yes, yes.
No problem.
No problem.
Do you need any interim?
Permanent alimony has been given, Milord.
Do you need no interim order?
No interim order. No interim.
Yes.
May I please do item 54? But here, my lord, the
Item
petition.
54?
But
54, yes.
here, my lord, the petitioner, it's a trap case under section 7, and the trial was going on.
Yes.
And my lord, on last occasion, my lord was pleased to recall and witness and directed that a singular opportunity to be given to the PW 5 and 6 to be examined or maybe spill over. I just to.
Yeah, you earlier occasion,
Yes,
let us
I
see the
appeared.
last order.
Yes. Again, my lord, again, what happened? Matter was before the Honorable Justice Aditya Mahapatra. Coordinated bench has referred this matter since my lord has already dealt this case here earlier. Your lordship's order is there. What happened, my lord? When my lord was pleased to allow the 311 petition and PW 5 was, my lord, he was declined.
Let me understand what
Yes.
the
Here, my lord, the petitioner is filed 311 petition.
5 and 6 fixed date report similar opportunity to the similar
Para 7.
Now what do you want with
Yes,
this petition?
after cross-examination the PW 5.
5 and 6.
5 6. Some confrontation, my lord. For ends of justice, 5 questions I filed a petition, Annex 3, before the London trial court. I need not have to confront the PW5 who has come later, cross-examine certain things, incremental materials have come against me. So I want to confront within 5 questions. Kindly see Annex 3. That is page 69.
Because I had said that you will get a singular opportunity.
Singular. And spillover done. Because some other questionnaires are given. Everything, as per Lordship direction, everything is done. When Miller, the PW5 came and crossed certain things, he has Miller deposed before the Honorable Court, which has to be confronted.
Long and short of the matter is, you want recall of this?
No, PW2 who was already examined and cross-examined. Kindly see the page 69.
No, I will not allow.
Page 69. Just Miller. Just want to.
I'll tell you why. See the earlier petition. See. The earlier petition, you sought recalling of PW 3, 4, 5 and 6. 1 minute. 3, 4, 5 and 6. I examined everything. I said that I will allow for 5 and 6.
My lord.
And I gave the opportunity.
Yes.
Now you are moving an application for 2.
No, kindly see the page 69. For your ends of justice, I am justice. Page 69. Annex 3.
All justices for cases only, not justice.
My lord, kindly see para 3.
Para 3 of
Para 3 of petition, Annexure 3, page 311 petition. Why I am justice to
why installmentally one after another?
That is one, but that you kindly see. Para 3. For the ends of just decision of the case, some confrontation between PW2 and PW5 is necessary regarding the fact mentioned in the detection report, for which following questionnaires are there under to put. Questionnaires. A. You have stated in your chief in para 13 that at the
you are
time,
going to ask this question too?
Only 3 questions I will ask. Nothing.
To
PW2.
Okay, yes.
Nothing more.
You have said paragraph 13 that you so.
Because, my lord, I will see.
1 minute. See whether the detection report was so. Whether so. And all these things were available to you when you crossed the PW2.
Signed.
Why have you not done it?
Mentioned
Today you become wiser.
No, my lord. PW5 after examination, cross-examination, he said, accused when he was taking his meal, the trap was in where the red. So PW2, I am not feeling lacuna, only to confront whether if you say or not say, I on my cost, I will.
You lead the defense evidence, whatever, but I am not doing.
My lord, the statement, accused statement is posted tomorrow. Initially, when petition was pending, I filed an adjournment application that was rejected, NBW was issued. When this petition was pending, despite the Vigilance Council pressed for issuance of NBW. My lord, NBW issued, ultimately Honorable Court protected me, directed me to surrender within 2 weeks, which is going to complete tomorrow. And tomorrow, accused statement will be done. In this juncture, only I pray for ends of justice because I have cited 2 judgments.
Mr. Mishra, I am so sorry.
I have 1 judgment. Supreme Court judgment.
Judgment will not do. See the conduct.
Yes.
You move application for recalling of 4 witnesses. I examine it, allow you to cross-examine 2 of them. Once that is over, again you are moving application under 311 for 1 more witness.
Only for limited purpose.
But why you have not moved earlier?
But earlier, after crossing.
No, you can't be wiser every day and keep on moving application.
5 and 6, well, evidence is closed. Only PW2 be closed.
I can do it if they don't have any objection.
They will have the objection, but they issued NBW. They are pressing hard.
Those things.
I am not. Only may not kindly consider, if not,
Yes.
They will hang me, my lord. They will hang me.
Why they will hang you?
Copy the date.
If evidence come without PW2 also they will hang.
Lord, kindly see.
Yes.
Kindly see.
Yes. Which paragraph?
My lord, para 9.
9.
Page 3. Yes.
9. Okay. Yes.
That is, my lord, I report give a reference. That is.
Read the relevant paragraph.
Yes, relevant. Section 311 of the Code of Criminal Procedure has engaged this court's attention before. Will abet to a few decisions of recent vintage while overturning an order of the High Court allowing an application for recall of a witness which was rejected by the trial court. This court is under in relevant Ratnamala corrections. In order to enable the court to find out the truth and render a just decision, these salutary provisions of
these are the general principles.
And because my threat, my conviction is only because unless until I confront this thing to the prosecution, it is justice not done, complete justice not done. But trial court only to ask.
Is there any procedure to be
I will
followed?
produce the petition.
No, for the accused, the accused is not bound for any procedure.
Yes,
There is a procedure. There is a pattern.
Pattern.
Of trial.
Yes, madam.
Trial can't go on the whim of the accused.
No, my lord, never.
You want that the trial
I never
proceed on the
dare-
whims. Why have you not moved application?
I never dare.
If some evidence later on comes
My lord.
and you want to confront, suppose now I'll allow two.
My lord.
If something comes, then you'll say that I'll
Your lordship, record my
examine someone else.
submission. Record my submission. Except three questions, I will not put.
What
I
is
will
the-
not.
What is the reasoning? Let us see the trial court order.
Page 72, last paragraph.
Mr.
Yes,
Please, I am
Yes, yes.
once.
Let us see.
Let's see. Lord. Well, page starts from 71. Lord, page 72. The lordship will see. The London Defense Counsel submits that, but para 3, that is not numbered. Para 3, your lordship kindly see. Though, despite filing 317 petition, time petition, my lord, the London Trial Court issued and put on the behest of the Vigilance Council pressed upon it, because despite my petition that matter is pending before the High Court, the warrant was issued. London Defense Counsel submits that witness Sanjay Kumar Subudhi, PW2, was examined, prosecuted, and discharged on 13/9/2023. He submits that some material questions were left by him, which is required to be put to him for just decision of the case. On the aforesaid submission, he submits to recall the said witness for his further cross-examination. On the other hand, London Special PP Vigilance vehemently objected the petition of the accused and submitted that the accused has intentionally filed this present petition in order to make the delay in disposal of the case. He further submitted the proposed question which have been formulated are not relevant to the facts and circumstances of the case, as well as the evidence already laid to by the witnesses. Peruse the case record. It is found that witness Sanjay Subudhi was examined, cross-examined, and discharged as PW2 on 13/9/2023. Thereafter, other charge sheet witnesses were examined. After closure of the prosecution case, the case has been posted for recording of the statement of the accused under section 313 CRPC. The defense has come up with a present petition
Good.
after
I did it.
Well,
Yes.
so if we have to produce the PW2 and PW3,
Keep it with this file. I'll pass the order. Yes. Next.
Let's
Give
go.
it to me. Pass the order. Yes.
55.
problem.
55.
Item 55, the appellant has filed this criminal appeal challenging the judgment order of conviction and sentence passed by the London Special
Press appeal.
Judge.
Press appeal.
Press appeal.
Sentence.
Sentence 3 years.
3 years.
3
3
years.
years and 23.
Appeal admitted, bail granted, and the realization of fine is stayed.
Name may be
Mr.
reflected on the
Mr.
top of
Sanjay
the
Das, name should be.
calls.
And call this. Okay. Yes. Next. 56.
That's LCR.
It's 3 years.
LCR call for.
3 years. LCR will be more.
7 PC Amendment
Same.
Act.
ठीक है, same more. 56 also.
57 2 years.
2 years, same order. Yes.
58.
I'll just come. Bail matter.
Application.
I'll just come with me.
Yes.
I'll just come. 59 urgent. One. I'll just come.
That is page 30.
Custody since
Custody since 9/7/23.
7/23. Okay.
The Lordship may kindly turn to page 30.
30.
Yes.
Yes. This is Kanu.
Yes.
Yes.
Kanu Charan Kahar. Right order so and so, your Lordship may then turn to page 31. Para 4, 5.
Acha, you said that it is 30 kilos.
30, 60. Each motorcycle was having 60 kg. 60 kg, 30 plus 30. Of the present accused petitioner was rejected by the Judge Special Court, Fulbani and so and so. In the meantime, 4 witnesses have been examined. Other witnesses are yet to be examined. The Honorable High Court has passed the order in so and so, so and so.
How many witnesses have already been examined?
Only 4 witnesses have examined out of 38 witnesses, and out of 4, I have annexed 3 witnesses.
Okay.
Seizure witnesses, your lordship may kindly turn to page.
I see. That Ravi Prakash judgment may come in your aid. So I'll call for the report from the trial court. What is the stage of the trial? If it is delayed, then using Ravi Prakash, you can be granted.
Yes.
Okay.
Yes.
Counsel, earlier the present petitioner has approached this court by filing BL appeal number 14127 of 2023, whereby although this court has declined to enlarge the petitioner on bail, but granted liberty to approach the trial court FRES, full stop. Subsequent thereto, the petitioner moved an application for grant of bail before the trial court. By the impugn order dated 12/8/2024, the bail application has been rejected. Mr. Sujata General and Counsel for the petitioner submits that out of 38 witnesses, only 4 witnesses have been examined. Petitioner is in custody since 9/7/2023. Since a year has already passed by, and while is not proceeding in an expected pace, a report shall be called for from the Court of Sessions Judge cum Special Judge Fulbani, District Contempt, regarding the status of the case in CT case number 100 of 2023. Lease the matter. Call for the report and lease the matter after 1 week or 2 weeks. 2 weeks.
Yes.
Let the report come with you. Yes.
60.
No.
Yes, sir.
The petitioner in custody since 2/7/2023, my lord.
Matter 3 weeks for a call. 3 weeks. 1 year out. 3 weeks out. 3 weeks out. Huh? 3 weeks. Yes. Yes. Yes, sir.
The petitioner in custody since 2/7/2023, my lord.
2/7/2023.
2023.
23.
Yes.
Okay.
For commission of alleged offences punishable under section 376(2)(n) and 506(I). In fact, occurrence took place.
376.
Yes, 2(n) and 506(I).
164.
In last occasion, my lord, your lordship has honorable court has directed to obtain the copy of the deposition.
Now 164, read it. Yes.
ଗୋଟେ ବର୍ଷ ଆଗରୁ ଦୀପକ ବୋଲି ପିଲାଟି ମତେ ଘରେ ଛାଡିବ ବୋଲି କହି ମତେ ଜଙ୍ଗଲକୁ ନେଲା, ଛୁରୀ ଦେଖାଇଲା, ଧମକ ଦେଲା।
That is what she has said.
ସେ said that ଜବରଦସ୍ତି କଲା।
Read further, sir. Read further. She promised to marry also.
Yes, my lord. ବର୍ଷେ ଆଗରୁ ଦୀପକ ବୋଲି ପିଲାଟି ମତେ ଘରେ ଛାଡିବ ବୋଲି କହି ମତେ ଜଙ୍ଗଲକୁ।
You forget. Read further. The last sentence, last few sentences.
ଆଣିଲା ସେ ମୋର ମତେ ଦେଖିଲା ଘରକୁ ଆଣିଲା, ତାକୁ ସବୁ କହିଲି, ତାପରେ ଆମେ କେସ୍ କଲୁ। ମୋର ଭାଇ
ତା ଆଗରୁ ପଢନ୍ତୁ ଟିକେ, ମ୍ୟାରେଜ କରିବା ପାଇଁ କହିଥିଲେ ଆପଣ ପଢିଲେ। Read that part. The part which favors him, you read it because it is bail plea.
ଗୋଟେ ବର୍ଷ ଆଗରୁ ଦୀପକ ବୋଲି ପିଲାଟି ମତେ ଘରେ ଛାଡିବ ବୋଲି କହି ମତେ ଜଙ୍ଗଲକୁ ନେଲା ଓ ଛୁରୀ ଦେଖାଇଲା, ଧମକ ଦେଲା, ମାରିଦେବ ବୋଲି କହିଲା, ମୋ ସାଙ୍ଗରେ ଜବରଦସ୍ତି କଲା ଏବଂ ସେଇ ଫଟୋ ରଖିଲା, କାହାକୁ କହିଲେ ଭାଇରାଲ କରିବ ବୋଲି କହିଲା। ମୋ ଭାଇ ମତେ ଦେଖିଲା, ଘରକୁ ଆଣିଲା, ତାକୁ ସବୁ କହିଲେ, ତାପରେ ଆମେ କେସ୍ କଲୁ। ମୋ ଭାଇ ତାର ଫୋନ ଆଉ ମୋ ଫୋନ ଦେଖିଲା ଏବଂ ଥାନାକୁ ଆଣିଲା। ଥାନାରେ ମତେ ବାହା ହେବ ବୋଲି କହିଲା।
He promised to marry.
Yes.
କିନ୍ତୁ ବାହା ହେଲାନି। ଆମର
Then there is a marriage also. 1 year. 1 year he has already undergone. What is the stage trial?
No, almost fag end of the.
Second, her statement has already been recorded.
Yes, my lord. I'm saying the same, my lord. The last occasion, your lordship has
What was the
directed-
statement in the court? Statement in the court. Get you fake end of the trial. You are saying
So
get that
that-
statement.
that is my submission, my lord.
Petitioner submits that
Let,
the
the
victim the trial is at the fake end of fake end, and the victim in the present case has already been examined. He undertakes to place on record the copy of the statement of the victim in the instant case. Leave the matter after 1 week. Yes.
61.
May I please?
You will get bail, sir. Please give
Yes,
it.
yes. I have already instructed the trial court advocate to do
Please get it so that you will get
here to
bail.
send.
Don't waste time. Yes.
May I please, Your Lordship? 20B2C of the NDPS Act, my lord.
61.
20B2C of the NDPS Act.
Recovery.
50 kg. He is in custody since 12th September 2023.
12.
September 2023. Local person. He has no criminal antecedent, my lord.
23.
No, my lord. 50 kg.
50 kg, my
50
lord.
kg.
My lord.
With all these conditions, he is in custody since 12/9/2023. Recovery of contraband ganja is 50 kilo. 50 kilo. And the other conditions are subject to verification. So, yes, granted.
Oblige, Your Lordship.
52.
May I please, Your Lordship, my lord?
Yes, sir.
Petitioner is custody since 8/11/23, my lord.
8/11/23.
23.
Okay.
Last time I had submitted the deposition copy, it was not there. It is there, my lord. Submitted, but could not be tagged, my lord.
Yes. Deposition.
Yes,
Ah,
ma'am.
which witness?
Victim is PW8, my lord.
PW8.
Yes.
Okay, read it. PW8. All the witnesses have been examined. How many witnesses are there?
Out of 20, 11 as you exam.
20, 11
Yes,
only.
yes.
11. Last witness was examined
in
June. In June 2024. Okay. Yes. PW8, read it.
Incidents, I'm reading, madam. He was a JCB driver. He gave his mobile phone number to me. He used to talk with me forcibly. After some days, his family members had brought his marriage proposal with me.
Where are you reading?
Page 2, madam.
Page 2 of the cross examination.
The page 2 the main, madam.
Yes,
See.
examination.
Yes.
Yes. The informant in this case is my
the-
father.
Yes. I am the victim. I know the accused. The occurrence took place last year. I was proceeding my study in class 9. The accused used to follow me, and accused was working in a road work in a village. He was a JCB driver.
He gave his mobile number to me, and he
he
used to talk to me possibly. And after some days, the family member brought his marriage proposal with me, with my parents, and I refused above marriage proposal to accuse. The accused kept me in fear, and so and so. When I had gone to call for nature in the oral action, the accused raped me in 2-3 times, and thereafter so on. So, what is your age?
My age is 20.
22.
23. 23.
The girl is
now 17.
17.
More than 17, 18 plus max.
But you will be convicted. The kind of
Yes,
evidence.
I will be convicted, but kind of the cross minor. She has stated nothing. This incident is of 2020 minor, and she is lodging the effort after I gave the marriage proposal. They denied. Thereafter, the FIR lodged minor in 23. Incident is 2020, and it is at our house, and she didn't disclose to anybody.
Today, what is her age?
My lord,
He is now 17.
17 plus
3 years means
10 months.
Yes.
Yes, till now it is 17, but at the time of incident, my lord, she was a minor, my lord. And now she has clearly stated that regarding the forcible
You will be
physical
convicted. That's the
relationship.
problem. Because the
Convicted,
evidence
but
is,
bail
if you are
may be
going to be convicted, why bail?
In her cheek.
Because the evidence is
No,
telltale.
madam. Cross race, she has denied everything, madam.
Show me the part of
Yes.
this.
Para 3, my lord.
Para 3, okay. I read up to so and so.
I have read up to plus 2. I am relevant, madam. Myself and the accused belong to the same caste. The mother of the accused had come to our house with the marriage proposal of the accused with me, and she left her house after taking lunch. The distance between my house and Latin is about 20 to 30 cubits, and one can listen to the shout of a person. If
Okay, see, there was a marriage proposal. Thereafter, all these things happen.
Yes, madam.
Even if he will be convicted for sure. If I grant you bail, then you will abscond definitely.
No, my lord. Any stringent condition because
even one absence will.
Yes.
The cancellation for entitled to cancellation.
Even single
of the-
absence in the
Yes.
Okay. Madam. Please accused in case also allegation in the petitioner is also. Petitioner is in custody since 11/8/11/2023. Out of about 20 charge sheeted witnesses. 11 witnesses have already been examined. The victim has been examined as an PW8. She in her examination and chief had stated that 3 years back, 2 years back, no?
3 years back.
3 years back, the petitioner was following 3 years back. The petitioner was following him and subsequently sexually assaulted her. Thereafter, the family of the petitioner brought a marriage proposal to the petitioner, and which was somehow could not be materialized. Hence, he has filed a FIR in the year 2023. The incident pertains to 2020 to the year 2020. In the cross examination, however, she has very categorically stated that the mother of the accused had come to her house with the marriage proposal of the accused with her, and the mother left their house after having lunch. Since they belong to different caste, the marriage could not be material.
Same caste.
Same caste. Same caste.
Yes.
Why marriage could not be materialized?
JCB driver.
Although they belong to the same caste, but the marriage could not be materialized owing to his profession, as a driver.
Yes.
JCB driver. JCB and driver. JCB driver. Since the petitioner is in custody since 8/11/2023, the incident, alleged incident, had taken place 20, and subsequently the FIR is passed up. FIR was registered after lapse of about 3 years, that is into 2023. I am inclined to admit the petitioner on bail with an additional condition that the petitioner shall appear on each date of hearing before the trial court. Before the trial court, failure for the petitioner to appear before the trial court on any date of hearing shall entail cancellation of bail. Cancellation of bail.
Obliged.
Now at least go and marry.
Yes. I am ready.
Go with the proposal.
Yes.
You stayed one year. It's better that, otherwise you will be convicted, I tell you, with the kind of evidence you have.
And then he will be acquitted here, madam.
At least if you get married and you can move an application on 311 and something you can do at this stage. Advise your client. Otherwise, 100% conviction. You have no escape. Yes.
My lords.
Yes.
63, I am there virtually.
Yes, sir.
Lords, here the state was asked to obtain instructions as to the status of the trial.
Yes, my lord, regarding the status of trial, my lord, I was contacted to the concerned IS, my lord. I need 1 week time to obtain the status of trial.
My information.
You are in custody since?
I am in custody since 7/9/2023, my lords.
23. Okay.
My information is that in the meanwhile, the victim and her mother, they have been examined. 5 witnesses have been declined by the prosecution. Next date stands to 20th of September. Victim admits, my lords, that she has accompanied the petitioner voluntarily, stayed in his house for 3 months, and to have had intercourse with him. And she also says, my lords, if your lordship will see her 164 statement, which is there with the state, my lords, she has stated.
What I'll do is I'll call for a report from the trial court itself. Instead of waiting for the state to get it, right now. Despite the fact that orders for, despite the fact that the direction was earlier for opinion regarding the status of the trial, the state council could not obtain the instruction for various reasons. Therefore, it is expedient that a reports should be called from the trial court. Which court?
That is, my lords,
accordingly,
the court of learned.
Special Judge
Special Judge Pokso
Balangir shall file a
in special GR case 73 of 2023.
73 of 2023. On the next date of hearing, please the matter along with the report. Meanwhile,
and the depositions of witnesses already exist.
Meanwhile, the state council is directed to you can get it.
Yes.
Council directed to get the deposition of the material witness.
No, that the court can send. The trial court can send it along with the report.
That will take again time.
No, my lord, it won't take much time because all records are digitized. So they will come along.
The trial court, trial courts also communicate the depositions. Right. Okay. 64.
My lord, play for adjournment. Play for adjournment.
Adjourn. October. Mr. Ponda's matter is after 3 weeks. And yes.
65, my lord, permitted to withdraw.
65?
Withdraw, my lord.
Withdraw. Withdraw. 65. Yes. 66. Yes. 66. Case diary has come.
Yes, ma'am.
Offense?
3763, 366, 3.
He is not there, agent. None appears for the petitioner in the interest of justice, agent. Yes. Notice on respondent number 2 is sufficient. However, none has entered appearance on her behalf. Yes. 67.
67, may I please allow?
Yes.
The FIR is unknown. In the meantime, one of the court is released on bail by your lordship. The exact similar.
By mistake.
No, it's just similar to my case, my lord.
This case was adjourned to 39.
Which one?
No,
This
39.
It was adjourned to 39/24. In the meantime, one of the co-accused persons was released on bail. For that reason, this case he has filed an interim application, and for that reason it was posted.
Your lordship's order.
Parity will be considered on the date of hearing.
My lordship kindly say 8/8. No, my lord, on 8/8. On the instruction of my lord, the case was adjourned to 13/8, my lord. But unfortunately, it was 13/9. This your lordship directed to list this matter along with this.
Wait, let us see.
Yes, ma'am.
Parity is there or not?
But the CD is not available. CD is available in that file.
Parity has to be seen.
My lord, your lordship kindly see. CD on 8/8, my case was listed. Lord and Council for appearing for the state.
You talk about today because he doesn't have the CD. How will I find whether you have the parity?
My lord, just a minute, my lord. I am saying what I am saying. My lord. On 8/8, the matter was listed. My lord and Council stated that the case diary is available in the case, my lord. Your lordship for which directed to come along with this case. In my case, your lordship kindly see the order dated 8/8.
It's not there.
No, my lord.
But
On 8/8,
CD is not there.
CD
The
is that
connected matter in CD is
connected
available.
matter the more case
That was a dispose of case. My lord, I will check up that whether the CD is available in that case or not. Otherwise, it will though
That
it was
case-
adjourned to 39. So I will check up, or your lordship may put up this matter to 39 on the same date it will be disposed.
Tomorrow, my lord, your lordship, one of the exact similar, my lord.
Tomorrow meeting.
You are accused in 302. You stayed for such a when you are in custody.
My lord, your lordship can see my 8/8 order, my lord. Your lordship's order, my
That's
lord.
right. I understand it. What you are in custody since?
Custody, my lord, on 13, my lord, 13, same day, my lord, he had, my lord, both the petitioner are arrested, my lord, this petitioner and
Give me the date, sir.
my lord, 16/5, my lord.
16/5/23.
My lord.
5/23.
My lord.
Okay, no problem.
Same, my lord.
You get ascertain the case diary.
My lord, I will
Only tell me that whether the Rahul Ponda,
My lord.
who has been granted bail, whether this accused has
Coming on the similar footing.
Roma Rauda.
Coming under the similar footing or not?
But that's all.
I will check on my lord. If CD is available in our office, then no problem. Otherwise, it will be taken.
My lord, what I am praying, my lord.
Tuesday.
Your lordship, Friday, your lordship, or otherwise, my lord.
Okay,
CD will
Friday.
return, my lord.
Let it be Friday.
CD will return, my lord.
Friday.
My lord.
68 my lord. The 302 millers.
Yes,
And
sir.
this my lord, bail application filed before this honorable on 26/2/2024 my lord. In the meantime, my lord,
Is there? Yes.
6 months passed. So by rejection order my lord taking my lord rejection.
You are complaining against this court or?
No, complaint more ko trial both sorry joni mu bhabuchi my lord, I'm not sure that at the time of my lord, February rejection order shows 9 witnesses have examined already. Now in the meantime 6 months 7 months going past.
Total witness. Well, total witnesses are 31 witnesses there. If some of the witnesses are examined, let him file the deposition copies.
No.
Trial for
He says that trial sorry running.
Let he take instruction.
So shall I put it next week anytime? You can tell next week anytime. Let him seek instruction.
My lord.
Status of
ଯାଉଛି ହଉନି ତେଣୁ କରି ଭଲ କେସ୍ ଗୁଡାକ ମାରିଲ
what to do?
ଆପଣ ଟିକେ ଗୁହାରି କରିବା କଥା ଆମେ ଆଉ କଣ କରିପାରିବୁ
We are trying to do as much as possible.
ଆଜ୍ଞା
Still things are
ଟିକେ ସ୍ପିଡି ମାନେ ଗଲେ ଟିକେ ପୁରୁଣା କେସ୍ ଗୁଡା ତ ସ୍ପିଡି ହେଇଗଲେ 7 ମାସ ପଳେଇ ଯାଉଛି ଆମର ଟିକେ
and you will be surprised there are people who are mentioning saying that we have been acquitted or people are coming and saying that we have been convicted.
ଆକୁଟାଲ ହେଲେ ବି ଆମ ପାଇଁ ଖରାପ ଆମେ କିଛି ପାଇଲୁ ସେଟା ଆକୁଟାଲ ହେଇଗଲା ଆମର କଣ ଖରାପ ଓବଲାଜି
Monday, Tuesday, Wednesday, you seek instruction. Okay.
69.
Yes, sir.
Offense under section 376(3).
376.
376(3).
3. Notice.
My lord, as for direction, my lord.
You should have filed requisite.
I'm sorry, I could not file.
And then your client will be sorry to stay inside. What to do?
I was on
Requisites could
impression
not be
that
filed, so
state-
therefore the notice to the opposite party.
There was the impression that state was
Could
taken.
not you file the requisites. These are bail matters. Don't
Yes,
delay.
yes,
My lord, actually, he has not filed. Another thing is that through police notice was also served. And I have taken instruction that notice was served on 23/8. Just 2-3 days back. my
You
lord.
do it,
Let
put it next week.
next week.
Service could not be requisites to be filed during the course of the day. Today only you file so that
By tomorrow.
by tomorrow. Yes.
I will try my best today.
Better that you file. So that,
Yes,
yes.
try
Next.
my-
70.
Yes.
May I please?
Yes, sir.
Custody since 3/4/23, my lord.
3/4/23.
Charge sheet
Okay.
submitted, my lord.
Charge sheet
Submitted on under 31/5/23.
5/23.
my lord.
Okay.
Offense under 376(2) and 376(a) of IPC and 6 of postcard. My case is that, my lord, once one situation of 73/23, while in that case, father of the victim was informant. While there, in that case of police investigation, and according to the statement 161 of the victim state
What is the offense?
Offense, my
See,
lord.
the problem with you is except rejection order, you have not filed anything.
My lord.
And everything is in
My lord,
air. You
my lord.
file something, at least let me see what are the offenses, what are the allegation.
My
At
lord,
least file the charge sheet, FIR, something.
My lord, what happened in this case? As the mother of the informant has lodged an affair. That is PS case number 70/23. During the course of investigation, the victim stated that this present petitioner has also committed rape. So police has
Mother committed again. This accused person has committed rape.
No, he has given name of the another accused person. Subsequently, mother. So during course of investigation, the victim, that minor child, has given the name of the present petitioner. So police, who is the informant, police has lodged this affair, and it was registered as PS case number 74/23. And my lord, in this registration was under section, charge sheet was submitted under section 376(2)(a), 376(a)(b), and 6 post. And notice was served on 26/8. Yesterday, my lord, notice was served. And my lord,
notice on opposite party number.
and in the meantime, my lord, 3 persons were examined.
Served through the state council on
26/8.
26/8. However, none appears for the opposite party. Leaves the matter. Opposite party, where is the opposite party? You have not informant for the opposite party, the informant, isn't it? because he is not implemented. He is not implemented.
Occupant already implemented as occupant
Huh?
2.
Yes, it is written.
Matter.
Okay, written. Opposite party number 2. So, however, none appears for the opposite party in the interest of justice. Agent 2. Next we got. Yes. Yes, next.
My lord, another thing is that out of the 21 charge sheeted witnesses, 3 persons were examined. He has to take instruction whether the victim was examined or not. Because the victim has given birth a child, 4 months child was there.
Child is there.
Child has given birth. My instruction is that child has already been given.
That is against to another.
Whatever.
That will be decided at the time.
Yes.
71. Wait, please, Lord.
Yes.
The alleged offence is under section 302, read with section 34 of the
You
IPC.
have CD with you?
Yes, ma'am.
Yes.
Lordship.
Yes.
302 with section 34 of the IPC.
Yes.
The petitioner is in custody since 22/9/2023.
22/9/2023. Yes.
Charge sheet has already been filed, and this is the bail after the charge sheet was filed. The allegation.
What are the allegations?
The allegation is that the main. I'm not moving for the main assailant. Main assailant is one Pintu Gowda. Pintu Gowda. It says that.
What is the overtake attributed to you?
I'm stating. There is no eyewitness to the occurrence. Everyone has stated that I have heard that the President Pintu Gowda, along with these, there are 3 separate bail applications. Along with these petitioners, they had assaulted the deceased, whose name is Surja Gowda, when he had gone to relieve himself in the morning, and his body was found in the a pond-like area. And after recovery, because we know that he had prior enmity with Pintu Gowda, we believe that he is the main asset. That is what.
My lord, the FIR, the complainant has given the name of the Pintu Gowda, and other Tuna Gowda and Rajani Gowda.
Tuna Gowda and
Rajani Gowda.
Who is the?
And others.
Kalia Gowda?
My lord, and the FIR was.
Kalia Gowda, Vikas Gowda?
No, my lord, I am coming to that.
Yes.
3 persons' name is there, along with other associates. That the FIR was lodged. Subsequently, Tuna Gowda and Rajani Gowda, FIR name accused person, they were discharged because they have no involvement in this case. And the reason
in
is
the charge sheet.
In the charge sheet.
Yes.
Only Pintu Gowda and these petitioners came into my lord.
What are the evidence?
Evidence is, my lord, that there is reason is, my lord, there is a long dispute between the
Pintu and the deceased.
These petitioners are the Pintu Gowda. So the Pintu Gowda has given in the confessional statement, he has stated the name of the present petitioner. And the investigation, my lord, shows that the farsa, the weapon of offense, it was seized from the present petitioner. That is Kalia Gowda, my lord.
Yes. On his disclosure or in disclosure of
his disclosure. In his disclosure.
27. You are reading
27.
Okay.
Farsa was seized.
What about Vikas and Santosh?
I'm coming to that. And CDR report also says that they were in one place. There was contact between themselves. And out of that, my lord, there are numbers of antecedents against the Kalia Gowda.
Forget about Kalia Gowda. Vikas and Santosh.
Then, my lord, because there is no antecedent, there is also
no recovery.
Nothing has been seized from the Vikas, and CDR, only CDR is there. Nothing is
and
there.
Santosh?
And my lord, Santosh, my lord, nothing has been seized. CDR is also not there. But 5.
I'm granting Santosh.
I'll just
5
small correction.
You be satisfied. Out of 3, 2.
No, Lordship, I'll just make it small. This is, even though what my learned friend says is right, that when your Lordship will read the.
No, I'm rejecting Kalia Gowda because of antecedent. Antecedent
both have Lordship, but there is no seizure from Kalia Gowda.
Whatever, but I'm not giving Kalia Gowda.
Lordship,
Vikas and Santosh.
The allegations against Kalia Gowda is only against under section 380 and 457.
Don't try for Kalia first.
Kalia Gowda is not entitled. Other 2 persons.
Right down. I recall in so far as Kalia Gowda.
First one.
2106. The petitioner is accused. Initial in the initial FIR, one Pintu Gowda and
Tuna Gowda, Rajani Gowda, and others.
It was in the initial FIR, the 3 accused names. These 3 accused were implicated. However, after investigation, charge sheet was filed. exonerating
Tuna Goda and
Rajini Goda.
Rajini Goda, and implicating
Vikas, Kalia, and Santosh.
Kalia Goda, Vikas, and
Santosh.
Vikas Goda and Santosh Patnaik. These three accused persons, above named accused persons, were implicated on the report. The confessional statement alleged to have been made by the principal accused
Pintu Goda.
Pintu Goda. It is further alleged that from Kalia Goda there is recovery of weapon of offense.
Yes.
Perfect.
Which is not on record.
And this accused has also antecedent. How many antecedents?
Against the Kalia, 5 numbers and
Criminal
antecedent.
antecedent, 5 number of criminal. Therefore, I'm not inclined to enlarge the petition, this petition on bail.
Lordships.
Hence, the bail application is rejected.
Lordships.
Same you should have put because also. Because Santosh. Although against the present petitioner, because although against this present petitioner, although the prosecution alleges against this petitioner that they were in the company of the principal accused Pintu Goda, who in his disclosure statement taken the name of the present petitioner. However, nothing is recovered from the present petitioner, and there is no criminal antecedent.
No arms were recovered, Your Lordships. Vehicle and other stuff are there. So, Your Lordships.
Weapon no, 27 is raid against these people also.
No.
Against
the Kalia.
And there is no recovery then.
Against the because there is no recovery.
Right down. I have written right thing.
Lordships. Recovery of weapons. They have seized mobile phones and otherwise.
But
so that
from,
way.
27 is not
Lordships.
Weapon, nothing is recovered. Under section 27 of evidence check. There is no criminal antecedent against it. The present petitioner is in custody since 22/9/2023. Hence, since no material has come on record against the petitioner attributing special overtake, I am inclined to enlarge the petition on bail. That they appear before the court without bail and single absence shall entail the petition on both the Santosh also same.
Madam, only Santosh will also mention there is 5 numbers of antecedent against the Santosh.
Now he said no, now he says yes.
Against the because there is no.
Santosh has to wait. Because they do fast to कर दिली विकास को दे दियो संतोष however I am not inclined to enlarge the petitioner on bail in view of the fact that he is involved in 5 other criminal cases liberty is granted to the petitioner to renew his bail plea after the informant in the present case is examined or within after expiry of 6 months, whichever Santosh next
72. May I please? I will BC, my lord. I am BC, my lord.
Yes.
The petitioner alleged to commit offence under section 302 IPC is in custody from 1st December 2023.
Yes, 1st December 23.
Yes, the deceased is the wife of the accused.
CD is there?
Yes, ma'am.
Yes.
That's already filed, you know. The deceased is the wife of the accused. The brief in that on 21/11/23 there was a sudden fight between the accused and his deceased wife regarding the purchase of liquor, and due to some fist blows and Bruce, she died after 9 days. And the cause of death is a loss of brain function. So the charge sheet
Cause of death is?
Cause of
loss
death
of
is
brain
the
function.
cerebral injury.
Loss
Cerebral
of
injury.
cerebral
Yes.
and a loss of brain function. The charge sheet has been submitted 29/3/20, and there is nothing was recovered from his position. Only the accused also sustained some minor injury during the free fight with the deceased. Though the death was not committed after 9 days of the occurrence.
Assaulted by means of kick and fast blow.
Yes.
Assaulted by way?
Kick and fast blow, man.
Excellent.
That the present petition is the husband. He has given 1,000 rupees to his wife to purchase some daily needs. But that wife has expenses that amount. For that reaching, there was a tussle between the husband and wife.
What are the injuries?
Cerebral injuries there only, and there's one of the eyewitness villager has seen matter. I'm reading that portion.
He was drunk.
Yes. Yes, she was drunk, Your Honor.
That one Pura Santa, relevant pilot, on 28/11/23 ରାତ୍ର 11 ସମୟରେ ତାଙ୍କ ଘରେ ପାଟିତୁଣ୍ଡ ମାରପିଟ ଶୁଭୁଥିଲା। ପାଟିତୁଣ୍ଡ ଗଣ୍ଡଗୋଳ ଶୁଣି ମୁଁ ଯାଇ ଶୀତୃ ଖରା ଘରେ ଦେଖିଲା ବେଳେ ଶୀତୃ ଖରା ଇଜ ପ୍ରେଜେଣ୍ଟ ପିଟିସନ। ଶୀତୃ ଖରା ତା ସ୍ତ୍ରୀ ସୁକୁଦେଇ ଖରାକୁ ରାଗି ଯାଇ ତାର ମୁଣ୍ଡର ଚୁଟିକୁ ଧରି ଲାତ ଗୋଇଠା ମାରୁଥିଲା ଏବଂ କହୁଥିଲା ସ୍ଲାଙ୍ଗ ୱାର୍ଡ।
He has not used any weapon and anything.
No, not any weapon.
Others
କହିକି ତାକୁ ଜୋରରେ ଠେଲିଦେଲା, ତାର ମୁଣ୍ଡ ଘରର କାନ୍ଥରେ ବାଜିଗଲା। Therefore, my lord, there is cerebral injury.
Oh, but there was no intention to kill, basically.
No, that is only
Grant me, right now. Petitioner is accused and FIR number so and so, allegation against the petitioner for it is alleged against the petitioner that the petitioner is the husband of the deceased. It appears that on 21/11/2023 there is a quarrel between them. The petitioner was in a drunken condition, had gave fist blow and kicked her gently. She her
head was assaulted by
very weekend. Accidentally she fell from the back and his head was hit against a wall. As a result of which the wife of the petitioner was admitted to hospital, and subsequently after 9 days he expired. 9 days she expired. The petitioner is in custody since 1/12/23. Since from the prosecution version, it appears that there was no intention on the part of the petitioner to cause to kill his wife, and the petitioner has not used any deadly weapon, rather given fist blows and kick to her wife, and accidentally she fell down, causing serious injury, head injury, which perhaps led to her death. I'm inclined to grant the petitioner on bail with the so condition. Granted. Yes, granted bail. Yes.
73.
73.
Custody since 46/12/23. Charge sheet already filed 23/4/24.
Sorry, madam. Custody?
26/12/23.
26/12/23. Okay.
Charge sheet already filed 23/4/24.
23/4/24.
24.
Okay.
That is preliminary charge.
Okay. Yes. What is the offense?
Offense 364, 365, 364A, 365A, 506.
You have to go to the trial court, madam, because your bail application was rejected on 12/2/2024. Thereafter, charge sheet is filed.
ଆଜ୍ଞା 9 ମାସ ହେଇଗଲାଣି ସେ ଭିତରେ ରହିଛି, ଏପର୍ଯ୍ୟନ୍ତ ନା ଚାର୍ଜସିଟ ରେ ଦଉଛନ୍ତି ନା ଇଏ ହେଉଛନ୍ତି। ଶବ ମିଳିଲା ଯେ ସେ ଶବ ବି ଆଙ୍କ ନେଇଗଲେ, ଖାଲି ଡ୍ରେସ ରୁ ଟିକେ ଦେଖିକି ଗଲେ।
What happened? The petitioner, he is a driver. He has called to work as a helper, mind. After 10 to 12 days, the informant, who is the wife of the deceased, he has made a phone call to the present petitioner. Present petitioner told that you give money, otherwise I will not give any contact number to your husband. This he has.
Thereafter, his dead body was
No, then my lord, after some days, my lord, there was dead body, a decomposed dead body was found in Udola PS. In Udola PS, my lord, your case was registered there, basing upon that unidentified dead body and decomposed dead body. My lord. Thereafter, the dead body is the photograph of the dead body. It was getting to all police station as well as to the GRP police to identify that person. Who is that person? Is there any missing report? Is there? So till date, my lord, neither the husband was rescued nor that dead body was found. Identified. For that reason, preliminary charge sheet was filed.
Charge sheet filed against the driver under 302.
No, 302. 364A, 365, 506.
When are you going to identify? If you don't identify everything,
though it is
and thereafter it's like a film after 2 years.
Decomposed body, neither it was identified nor postmortem.
When are you going to identify? Identify, you have to do it.
It was given that the face.
But even decomposed body, you can take a DNA test or something. Scientific test, you can do it.
Yes.
Who stops you?
But it was communicated to all the police station and railway station. No missing report.
No, but you keep on doing for years together. How you will handle him?
That is the fact, my lord. Because
so you tell me, undertake to this court that you are going to do it. Otherwise, I'll enlarge her.
DNA test to
1001 way of doing it in scientifically. You very casually you are given letters and he is there in jail. If somebody is in jail, you have to do it very expeditiously, na?
But that reason that though his husband was not rescued till date, so he's think that this dead body belongs to the informant's husband. Neither it was identified nor the PM report was conducted. Whether the DNA.
You give instruction to know that if by next week you don't get some scientific evidence, and some attempt to do some scientific evidence, I am granting the bail.
Yes.
I will talk with the IAC.
Next Tuesday, Wednesday.
Yes.
You remind me so that. Because see, you identified, then
yes.
You have a case. No,
other person.
What to do?
If that identification will made that he is not the.
And it is not a kidnap case also, because he has gone for working.
Yes.
How can you make out a case and a preliminary charge sheet you filed?
On the basis of that, informant stated that he demanded money to talk with the husband.
That is a different story. But has he been kidnapped?
No, madam, not kidnapped.
Then what? Even the preliminary charge sheet has to go.
He herself stated that he has gone.
Merely because wife asked that give the number of my husband, I want to speak. He said that pay money, then I'll give you. That is the
only
offense.
that reason.
And he is in custody about
custodians 26/12/20. 8 months, madam.
Witness, come what may you say. Otherwise, I am granting the bail.
Madam.
Yes. Okay.
74.
May I please also?
Yes, sir.
The person is in custody, my lord, since 25th August 2023, my lord. 25th August 2023.
23, okay.
Charge sheets submitted on 26/11/2023 under section 498, 304B, 306, 34 IBC, ready section 4 declared.
Yes.
And the cause of death, my lord, suicide is hanging, my lord. And the
your husband?
My lord.
What about the other family members? They were accused.
My lord, 74, time, my lord.
Sorry?
CD has not come, my lord.
CD, call for CD. Okay.
Mother-in-law was enlarged.
Okay, CD, let the CD come. Huh? Call for CD.
CD may be in 1618. In BLA PL number 1618 of 2020.
It has already been granted. Bail has been granted. Though fresh CD, he has to get
16.
Okay.
161.
Call for CD. Next.
75.
Fix a date.
Date will.
May I please, your lordship?
Yes.
The petitioner is in custody since, my lord, 28th July 2017.
17? Oh.
More than 7 years is in languishing jail.
What is the offense?
C02-201 34 IPC. My lord, what happened?
What is the state?
In the meantime, out of 27 charge sheet witnesses, 11 have already been examined.
27.
I am filing the certified copy.
No, I don't need any evidence has come against you.
Nothing, my lord. The 3 accused persons. One Sonu Munda, Santanu Munda, and the present petitioner. Sonu Munda and Santanu, they both are juvenile. Sonu Munda is the son of the deceased parents. He approached his mother to give handia. She refused to give her. Then he attacked by means of a wooden plank. He was a juvenile. Then with the help of the present petitioner, that was thrown to the river.
He has helped to
with that
principal accused is that juvenile.
Yes.
Who has given the blow. And he
They
has
both
helped to
Santanu-
dispose of the dead body.
Only my lord. Last 7 years in custody, and the main principal accused.
It's the case of double murder. That the father and mother, the present petitioners, they are the friend of the principal accused, that is Sonu. Sonu is the son of that deceased man, father and mother. They have
Sonu killed his mother and father.
with,
And
with the assistance of these present petitioners.
Assistance what? For killing or for
Because they have made, after killing that father and mother, they have thrown the dead bodies to the river. Then after they have confessed before the Grammarachi, my lord.
Ward member. Informant.
Regarding extrajudicial confession that we have killed. Basing upon their statement that the dead body was found from 3 kilometers away in the river, my lord. That the father's dead body was found. Till date, that mother's dead body was not found, my lord. And subsequently, my lord, that the PM report is, my lord, there is some structural injuries. And that
father of the principal.
Only father body was found.
What are the evidence against them? This man.
My lord, that is the one bala, the weapon of offense that was seized from the Sonu. And basing upon total the confessional statement, they were, my lord, they have made extrajudicial confession that we have killed. And my lord, if you will connect,
so
my lord,
weak evidence you have against them.
my lord, that is a fact, my lord. If
7 years.
My lord, if we have connected that matter, my lord, basing upon their statement, a dead body was found. Because they have stated that we have thrown the dead body to the river.
I'll call for a report from the trial court and enlarge it. And I'm calling, I will not go into all
And
this
that
right
is,
now.
my lord, apart from that, the two minors, my lord, what happened, my lord, that the grammar,
they are juveniles.
No, they are eyewitnesses are there, son and daughter of the deceased. They were the eyewitnesses.
Have they said against
Yes,
this
my lord, I'm
man?
reading that. My lord, I'm reading that.
They have been examined.
No, my lord, 11 witnesses out were examined.
The informant, Kaira Munda, he has turned hostile, my lord.
No, eyewitness I'm talking about.
Eyewitness, my lord.
The children were examined.
Saban Munda is the 11 years. His brother, the Sonu
No.
Munda's brother.
In the spot, the children were there.
Children, my lord. One is
The
11 years.
other brother and sister of the principal accused. Have they seen the incident?
11
Whether
years.
they have been examined or not?
My lord, that instruction is not with me. Whether he has to say whether they are examined or not.
The petitioner is in custody since 28/7/2017. Out of how many charge sheeted witness?
27, my lord. Out of 11 constitution have been examined.
Out of 27 charge sheeted witnesses, 24 charge sheeted witnesses, 11 witnesses have been examined. The petitioner is in custody since about 7 years. The trial is still proceeding. The trial court is directed to submit a report before this court regarding the status of the trial and disclosing as to whether the eyewitness to the occurrence have been examined or not. Leave the matter after just 1 week. And I'll just see and
my lord, that name may be reflected, that eyewitnesses.
Yes.
That is Saban Munda, Jema Munda, and Jagan Munda. Whether examined or not.
I have said eyewitnesses. The trial court will say these are the eyewitnesses.
Now, by a flux of time, they have become major.
Naturally. 7 years, what evidence you are going to get?
But that eyewitnesses are there. That is the evidence. Eyewitnesses and leading to that. What was found.
And what but also to indicate the timeline for examining the eyewitnesses. Date he will give a date. All matters date will be given. Yes.
76, my lord. On behalf of Tanmay Kumar Mahanti, the prisoner petition is there. He filed a wakalatnama today in court for the registry.
Yes. Mr. Tripathi, okay, and so on, so entered a clearance. Leave the matter after 1 week. Yes, next.
Wakalatnama can be taken.
Wakalatnama, you file it because already filed.
I have a copy of the.
And his name should be reflected in the court. Deleting the name of Mr. Tripathi. Okay.
77.
I have the receipt, madam. I have already filed, madam.
Delete the name of Mr. Tripathi and enter his name.
Tanmay Kumar Manti, can be.
Yes, sir.
Madam.
77.
Yes, sir.
Offense subsection 376B.
376AB. Okay. Custody.
Custody 11/10/23.
11/10/2020.
11/10/23. Yes.
Madam, if your lordship go through the 164 statement, madam. The victim has stated that Gotte Puo. He has not also whispered the name of.
Do you have CD?
Madam, can you
Yes.
see that? 164. 64.
Except FIR, you have not filed anything. Read it out.
Minor child, my lord.
Minor child.
Explicit. Basically, what is this? Tell me. What is your age?
My age is 28.
Wait. Wait till the team and
He has
informant.
not whisper my name. He କୌଣସି ପିଲା ଆଉ so far as that overtake matter, he has not stated matter. Only he has stated, if your lordship has gone through matter. He has stated that I have offered him, he denied, he went back. Nothing, I have not also.
See the other very particularly she says. Very particularly she says what had happened.
So what had happened? There is no overtaking. He has only stated manner that I have offered him that price. He denied.
30 rupees you offered
yes. And he denied. He went away.
Thereafter you have done it.
No,
that's what he says.
Yes.
He says.
Heinous
girl.
Yes, heinous man. Your lordship is right. I am not.
You are 29 years.
No, my lord, he.
Wait till the witness she is examined. I have perused the statement of the victim recorded under 164 CRPC regarding head to the allegation of the petitioner. I am not inclined to enlarge the petitioner on bail. However, petitioner is granted liberty to renew his bail plea after the victim is examined. It is expected that the trial court shall do well to see that the victim is examined as a witness number one, witness number over all other formal witnesses, by giving preference over all the formal witnesses. If the victim and other material could not be examined within 6 months, the petitioner may also renew his bail plea. Whichever is earlier.
Madam, 76 I prefer fixed date, madam.
Date will be fixed, don't worry.
My lord, another thing, madam. Though 376 AB was there, so notice was served to the informant on 28/3/24. That may be reflected.
Despite notice to opposite party and appear. Yes. Despite service of notice to them. Yes.
78.
For rejection, notice is not required. For granting bail, it is required.
Only indication that the notice was served.
Any order you have to had the opposite.
That's right, but rejection, no prejudice. Yes.
May I please?
78, huh? Yes.
Custodies in 16/8/23, my lord.
16/8/23,
my lord. Occurrence took place 8/8/23. And FIR lodged on 15/8. For the offense under section 371 506 of IPC, my lord.
Yes.
And charge sheet submitted, my lord.
When?
Charge sheet submitted, my lord.
Charge sheet.
My lord. Charge sheet.
When charge sheet submitted?
Charge sheet dated.
Release it after 1 week, huh? Next week. Yes, next. 79.
17, I pray for an adjournment, my lord. I want to obtain status of the
80. Come fully prepared, sir, because I don't have that much time. So you can't read here. You immediately you have to tell, otherwise it will be urgent next week. Because you see the pressure. I can't wait till you read and
5/10
whatever you next week I'm thinking. 1 week, Tuesday, Wednesday. Okay. Yes. Yes, sir.
But listener, when accused for an offense under section 498A 202 and subsequently charges submitted on the 20 added 498A 302
302 is there.
SC/ST also there. SC/ST.
Okay, no
problem. SC/ST.
No problem. That is not issue.
Put SC/ST.
You are the husband.
I'm the husband. But on your file.
Charge sheet is 302. Okay.
80/80. Chokwa, yes. 70.
What is the outtake?
Pardon?
What is the outtake attributed to?
Allegation that the petitioner married to the deceased 20 years back. Subsequently, he took another widow lady who is both are from the scheduled caste.
Incident you talk about incident.
It is alleged that after taking liquor, he used to quarrel, and there was sometimes he also assaulted his wife. And it is alleged that prior to the 2 days of the occurrence, there was a quarrel and he assaulted by means of and injuries are on the leg and knee, all injuries are. Cause of death is due to
did not took her to hospital also. And he has admitted that I have beaten him and I will not take care of her.
No, beaten him, but whether in the vital part or intention to kill or those things.
He did not took her to medical also.
And injuries all are bruises and abrasions on the knee and the leg. And the cause of death is due to peritonitis and its complication. It is internally is a layer of the in the stomach. If it is infected from the fungus, that is that cause peritonitis. That is cause of death is due to that. And injuries, external injuries, all are
that injury is caused by you earlier.
No. The allegation that taku badela mugote statement podi dochi relevant part di line. Se am samnare sukra.
Where is the medical evidence?
Medical evidence postmortem report I am first time external appearance. Injuries are bruises of size so and so of below the lateral aspect of the right thigh above the joint. And injury number 2 is abrasion of side so and so on the left side of the chest and below the
in medical aid, given medical aid to the petitioner has also come on record. In that view of the matter, I am not inclined to enlarge the petitioner on bail at this stage. However, the liberty granted to petitioner to renew his bail after the material witnesses are examined with the present case, or after 6 months, if the material witnesses cannot be examined for any reason. If such bail application is moved at that stage, the trial court shall consider the same on the basis of its own merit, on the basis of the material available on record then. Yes.
81.
81. Very good. This is the best thing you could. Yes.
82.
Yes.
82, may I please, your lords?
Yes, sir.
My lord. The petitioner is in custody since 1912-22, my lord.
1912?
22.
Yes.
376 and POCSO, my lord. I have filed the 164 statement, Annexure 4, page 16.
Yes. Yes. She has not yet been examined?
No, my lord.
Yes.
She has took birth a child, lords. She has took birth a child.
Kindly peruse page 16, my lord. 164 statement.
Only if he will file a affidavit that he will marry her, then only.
There was no promise to marry. There was no forcible intercourse. And age of the victim is 23 years, my lord.
What is it? 23 and this.
In FIR, she stated 28.
You are 20 years. You are 20 years.
Yes.
She is 23.
No, no.
No, you say, see, your bail application you have written, your age is 20 years.
Yes, my lord, my age is 20 years.
And 164 statement,
she stated,
she says that I'm 23
years.
What is this?
And FIR, she stated 28, my lord. She herself lost the FIR.
What is this? So how will you get FOC? Madam,
Yes,
Madam, petition is accused and so and so, so and so. The petitioner, the victim has been examined the statement of the victim under section 164 CRPG has been recorded by the police during the investigation. In the her statement, she has stated that she is 23 years old. She was in relationship with the petitioner.
What's the date of birth of the victim is? It is 16/8.
It is there, annexure 4, just see, that is there in front of me. My age is 23.
No, Lordship, payment is there. That from the
I don't know. I'm recording whatever is transferred.
But from register it is there. That is
whatever.
CG.
I'm recording
at the time of the
I'm
occurrence.
not giving judgment on conviction. I'm granting him bail because of this kind of evidence. I don't.
Lordship, say only bail should be provided if you will agree for the give the affidavit.
Read. Can I read the statement 164? I'm reading it. Move so and so.
Medical.
1 minute. Move so and so. আজি এই অদালতরে ଏହା ବୟାନ କରୁଛି ଯେ ମୁଁ ଆଉ ମୋ ଗାଁର ମାଝି this accused who is 20 year old ଭଲ ପାଉଥିଲୁ, ତାର ମୋର ସମ୍ପର୍କରେ ମୋର ଗୋଟେ ଛୁଆ ଅଛି, ଏବେ କୁଳ ମାଝି ମତେ ବାହାବାକୁ ମନା କରୁଛି. This is 164.
But documentary evidence there that she is 16 years 11 months.
And they had physical relationship out of their relationship, a child was born. However, since the petitioner has refused to marry her, she has filed the FIR. In the FIR, the name, where does say 28?
Age first line, man. Mu Lalita Majhi, 28 ବର୍ଷ.
FIR also, she has written her age to be 28 years old. The petitioner is stated to be 20 year old. Petitioner is stated to be 20 years. Although the fact that although the medical evidence indicates that there is sexual intercourse and there is a child born out of the alleged relationship. But the fact remains that the relationship is grown due to the love affairs between them, and the petitioner himself is a 20-year-old boy, and he is in custody since 1912-2022. You are in custody since 1912-2022,
my lord.
I'm inclined to enlarge the petitioner on bail.
Let's see, we should evidence that date of birth is 6/15/2006. That should be written.
However, for the state submits that says that the evidence collected by the police indicates that the date of birth is
15/1/2006.
15/1/2006.
Date of occurrence is 16 years, 11 months.
Therefore, on the date of occurrence, her age was about 16 and a half years.
16 years, 11 months.
16 years, 11 months. 11 months. 11. Who would have for a bail? So, yes.
Obliged.
83. Therefore, he opposes the bail. Right.
May I please, this is a case under section 493, 417, 306 by 30 for a IPC and section 313. 313.
Okay.
But in the charge sheet, my lord, 313 has been deleted.
Okay. Custody?
Custody since 20th February 2024.
20?
February, my lord. 2024.
20th April 24.
February, my lord.
20th February 24.
February 24.
Okay. Yes.
And
tell me what are
charge sheet submitted under section 493.
When charge sheet?
Charge sheet submitted 20th April, my lord.
Okay. Now custody also 20th February.
My lord.
Okay. 24, huh?
My lord.
Yes.
And charge sheet submitted 493, 417, 306 by 34 of IPC. And the cause of death is suicidal hanging, my lord. Yeah.
Yes, sir.
Initially, my lord, there was a love affairs between the petitioner with the victim girl. After the petitioner,
show me that
the petitioner denied to married. After that, my lord, she committed suicide.
But your bail application is rejected in 4/3/24.
Suicidal notice there.
But
thereafter charge sheet was filed.
But this is a case
during investigation you approached.
Yes, my lord, that is a case of 493 and 306, my lord.
So that time the offences were heinous. Therefore, the trial court is rejected. Now,
no, my lord, that is 313 was deleted in the charge sheet, my lord.
That time charge sheet was not available. But you go to trial court.
Yes, my lord. But this is a case of 493 6 only, my lord. Only charge sheet submitted and it is in custody since February. Suicide, my lord.
There.
Suicide by hanging.
My lord.
Bolted from inside.
Yes.
Show me. Show me that bolted from inside. You have not filed anything, therefore I can't get it.
I have given the charge sheet also.
Where is the charge sheet? You given means you have filed, sir. Mr. Mishra, and counsel for the petitioner, seeks 1 week time to place on record the copy of charge sheet.
I will file after lunch.
Case, huh?
I will file the after lunch. Charge sheet is with me also.
At midnight, I'll hear you.
No. Charge sheet already filed.
I'll put it in next week.
Okay.
At least the matter. Let him do so.
Next week,
by tomorrow, you do it. Next week. Okay. And only show me that the suicide, she has committed suicide, bolting the door from inside. Then,
yes, ma'am.
Okay. 84. File it and neat copy you file so that at least I can read it here. Okay.
Item 84, I may be permitted from VC, my lords.
Yes, yes.
My lord, the petitioner is in custody since 6/5/2018, my lords.
6/5/18,
my lords.
Yes.
More than 6 years inside custody and charge sheet submitted 363, 376 IPC and section 4 POCSO.
Yes. What?
Yes, conducted for 5 years. Then.
You absconded then, obviously.
Yes.
For how many years you have? 5 years. So therefore, nobody is giving you bail. What to do? What is the stage?
363, 376 IPC and 4 POCSO.
How many witnesses are there?
18 witnesses.
18?
18.
18 witnesses.
Yes.
3 examined so far. 2018. 6 years.
So any
let us call for a report. Huh? Let us call for a report. The petitioner is in custody since 6/5/2018. Out of how many witnesses?
18.
Out of 18 charged witnesses, it is stated that only 3 witnesses have been examined. A report shall be called from the court of Special Court under POCSO Act, Mayurbanj, Paripada, in city case number 62/4/28. Okay, please the matter. Yes.
Deposition copies may be also called.
Yes. Yes.
May I please issue lordship, Lord. Petition is in custody.
85?
85, lordship.
85 na? Yes.
That matter, your lordship. Matter petition
Yes,
is is
sir.
in custody, Miller 6/3/2024, Miller. For the commission of offense under section.
No, last item. Yes. Yes.
Miller
Yes, sir.
petition is in custody 6/3/2024, Miller.
6324.
Offense under section 376(2)(n, Miller. Charge
Yes.
sheet was submitted.
Hmm.
30/4/2024. Same offense, Miller 376(2)(n, Miller. Development of the case in the meanwhile, Miller, both petitioner had gone interim bail for marriage, Miller. After marriage, voluntarily surrender. In the meanwhile,
They married.
I'm married. Affidavit also with my lords, Miller.
Yes. Great. Grant bail. Right up. Petitioner. Where is the interim bail?
Interim bail, Miller, 1/7/2024.
Huh?
1/7/2024.
Right. Petitioner is accused in FIR number 2 allegation against the petitioner approved. On 1/7/2024, the coordinate bench of this court enlarged the petitioner on interim bail. Interim bail. Where does it say that you marry or what?
Affidavit was filed by the informant.
Interim bail. Interim bail. After the petitioner was released on interim bail, petitioner and the victim informant.
Yes.
Victim informant has now married. Where is the marriage certificate? Where is the marriage certificate?
Certificate is with me, Miller. Affidavit, she has given affidavit.
No, I don't know whether she has given or somebody else has given.
No.
Somebody else has
Before oath commission, before oath commission.
Oath commission. In here, anything can happen before.
I have filed करेनी.
Show me the marriage certificate. Finish. I'll take that from you.
Date नहीं था.
What is this? Who has issued this?
ଆମକୁ କରିଛନ୍ତି. ଆମକୁ marriage କରିଛନ୍ତି.
What is, who has given issued this marriage certificate? What is this? AMOFOI? Tell her to appear in
Lordship, my brother is appearing for the informant.
Maybe I'll
She has
given. For your safety only, I'm saying.
Yes.
Tomorrow, that girl I am not married.
Yes.
And you people will be in trouble.
Your Lordship, keep it on Friday.
Tomorrow, today at 2 o'clock. Tell them to appear in VC. I'll just see them. I'll verify and do it. I'll grant regular bail. What is the problem?
Tomorrow.
Okay, tomorrow. Because it is for your safety, I tell you.
Yes.
They'll turn around and tell that the lawyer has done it. Unless to create that problem.
An affidavit before the oath commission. Sorry.
You know what kind of things happen outside. Some girl might have stood there and signed. You never know. Tomorrow you people will be blamed.
Yes.
Tomorrow. Huh?
Tomorrow.
Yes. Let her appear on VC and simply
Yes.
so that I can record she appeared in the VC. Then you are free.
Yes.
Yes. Okay. 86. Yes. Thank you. Huh?
93 also.
93 withdraw. Yes.
Already member there. 87 and 88, your lordships. Their lordships, no annexures are up to me, lordships. I have been noticed.
I'll just take it up. There is nothing
May I pray, let it be come in next week or any other date, your lordships.
Who is appearing for petitioner?
The state has filed for the.
Apply the copy.
Yes. No.
The 87, 88. Huh?
87, 88.
87, 88. The Learned Counsel for the opposite party submits that the entire annexure attached to the petition has not been supplied. The state council is undertaking to supply the copy during the course of the day, least the matter next week.
Item 89, your lordship.
91, he has a personal. 91 also.
Millards, I may be pardon item.
I will come and see you.
Item 89.
Do you want me not to come? I'll come.
Soon after lunch, one matter is fixed. Report number.
You need not come. Note it down.
I'm for the OP number 2, 3. I'm for the petition.
1 minute. Both the sides agrees, give that date. But all of October, not before that.
89.
I'm not talking.
Also non appeared.
My lord.
This petition is filed on 27/4/2024. When the matter was taken up on 13/5/2024, none appeared for the petitioner. Even on the second call today, nobody appears for the petitioner. It seems the jury is not interested to prosecute the present matter. Accordingly, it is dismissed. Yes.
Disposal.
May I please your lordship?
Reflects. Appear for 2, 3, 4. Opposite batch number 89, huh? Yes.
My lord.
Pray for some time.
I have prayed for cancellation of bail to this opposite party number 2 to 4, my lord, because the IIC Loisinga PS under Annexure 4 filed an application before the learned court below to cancel the application of the petitioners because 10 cases and other 2 cases during bail, my lord, 12 cases had already been registered against these 3 accused persons by the same informant and his wife, my lord, because they are in litigated term in a civil suit, and the civil court has also restrained them not to enter into the suit land. But my lord, they are creating havoc and they are not allowing him to leave even. 12 cases have been, the IIC was constituted to file this application under Annexure 4, my lord. And
IIC filed.
IIC filed, my lord. Annexure 4, your lord.
Between the parties, man.
No, civil dispute doesn't mean that you create.
No, both parties are giving cases, case, counter case, both parties are.
How many cases are there against the complainant?
I am not exact, sorry, for that
10
we
cases
pray for.
10 cases against you.
Yes. Thereafter on that 10 cases previous, on that case.
After you were enlarged on bail, how many cases?
One case. One case.
How many cases are against the informant?
That information I will be getting a reply.
So entered appearance on behalf of the opposite parties and seek 1 week adjournment for filing the response to the petition. Please the matter. Yes.
Lord, I pray after 11th September, my lord.
11.
After 11, any day. Great.
Yes.
90.
May I please, Lord?
Yes.
In this case, the son and daughter-in-law have lodged an affair against the parents, my lords, old parents.
Yes.
Offense under section 492, my lords. I pray for question of cognizance because, my lords, I kindly have a glance at page number 30, my lords.
30,
my lords.
Okay.
That the family welfare committee report, they are saying that the allegations are false.
Welfare committee.
Yes, my lords.
Yeah, but that's what I asked. Charge sheet is filed. The welfare committee report is of which date? Is of 31/1/2018. The charge sheet was filed on 22. 31/22. That report may be much prior to that, before the FIR was registered.
No, my lords. After the FIR was registered, this report was done.
When the FIR was registered? 31/1/2018.
My lords.
And this is 31. Same.
Yes, my lords.
Same date.
Yes, my lords. The opinion they have stated that the
opinion maybe after this the FIR was registered.
Yes, my lords. But the Honorable Apex Court had stated that the opinion of the Family Welfare Committee.
But the cause of action for filing the FIR is subsequent to this.
My lords.
That's the problem.
These are old parents, my lords, and the son and daughter-in-law are living happily at UK, my lords. They are not pursuing the case, my lords.
Yes.
And the
National also directed me to take instruction, and though I have given letter to the IAC, my lord, the case diary and other relevant person.
Well, see, they are parents. They are parents. That is the reason I am interested to quash it in the sense these wife and husband they are staying in America. Why should these people suffer?
But it was listed on
What is the stage of the trial?
20th.
Cognizance has been taken.
Yes, madam.
Mr. Raghunath, learned counsel for the state seeks one more week for seeking instruction in this matter. Lead the matter. Date will be, yes.
91.
Agenda.
92.
Yes.
It's that factory boilers case, my lord.
Jamie. Yes.
Notice or
Intercases.
Respondent note 3.
They are not.
Respondent note 3, service.
Delivered.
Huh?
Delivered.
Delivered.
Yes. When it did. We will wait. Service has been completed. In the interest of justice, we will see that the service on opposite party number 3, although is complete, but nobody has entered appearance as yet. In the interest of justice, by way of last opportunity, one more chance is given to the opposite party number 3 to contest the case. Please the matter on such said the interim order passed earlier shall continue till next date of hearing. Yes.
My lord, 4 matters are there.
All the 4 matters. Interim. Yes.
94.
It will come.
He'll give a date. After 2 weeks or 3 weeks.
Withdraw.
94.
92 I withdraw. 93.
94. Opposite party number 2, service.
Notice could not be issued written on such
Did not filed. Huh? On the last date of hearing, this court had issued notice to opposite party number 2. However, learned counsel for the however the petitioner has not filed the requisite for effecting service on opposite party number 2. None appears for petitioner. Therefore, it appears that petitioner is not inclined to prosecute the present matter. What is this matter about? Hence, quashing, huh? Quashing.
Quashing.
Hence the same. Yes.
95.
Release of vehicle matter, your lordship, 457 petition has been rejected by the London Special Judge, your lordship. Offense 20B2B of the NDPS Act, 10 of ganja has been seized from the vehicles. Vehicles is Swift Desire vehicle, your lordship.
You are the accused. Yes. Confiscation is proceeding is going on.
Yes.
Going on.
Yes.
You have the particulars of confiscation proceeding.
1 page note only. 3 page note only is there.
Do you have any idea about confiscation?
Contractor search incident and confusion.
Vehicle confiscation.
Hmm.
My confiscation proceeding, so far I have obtained the instruction, my lord. No confiscation proceeding initiated against him.
Then,
my lord.
Then it has to be allowed.
My lord.
Right. The petitioner is agreed by the order dated 12/11/2021, whereby his application under section 457 CRPC for releasing of the vehicle. What vehicle? Car.
Swift Desire
Desire car bearing number OD 15R -02 has been rejected. The trial court has rejected the application of the petitioner by the impugn order dated 12/11/2021, entry area stating as under. Where is that? What are the grounds?
My lord, main ground is relying on the judgment of this Hon'Ble Court passed in Jitendra Kumar Digel versus State of Odisha. Here the petitioner is the owner and accused. On that ground, my application has been rejected, Your Lordship. Page 22 of my application, Your Lordship. Page 32, sorry, Your Lordship, 32. Paragraph 17.
Right. You have any judgment in support of you? Have you read the impugn order?
Yes, Lordship.
It says that there is no provision of interim custody because they have not initiated confiscation proceedings.
My lord, on that ground, Your Lordship is directing for release, Your Lordship. In some cases, I have heard.
Show me some judgment. You are not prepared, it seems. You prepare it. Huh? I'll put it next week. See, the court says that there can't be an interim custody. That is the reason given. I have to deal with the reason. So you have to give me some judgment so that
Matter is pending before the Honorable Chief Justice Court, Your Lordship.
What? Which
This matter, these questions, owner accused in a case of NDPS, release of vehicle matter, Your Lordship.
This court.
My lord.
So get those things.
My lord, that is sub judice, Your Lordship. Not final decision has
So
been
get
come.
those things. Let me
And
see.
the last judgment which has been passed by this Honorable Court, Division Bench in Chief Justice Court, directed to release without mentioning about the accused is the owner, Your Lordship.
That's what I'm saying, sir. Please get those judgments.
Yes,
Let
yes,
me-
Lordship.
Please.
That judgment has been mentioned in this order, Your Lordship.
Please better next week or 2 weeks.
96.
Item 96, let's say I prefer 1 week time for it to defect, to remove the defect.
Within 1 week, defects will be removed. If the same is not done, same order shall be dismissed without reflection.
27.
97, may I please?
Yeah.
One complaint case was filed after the final form submitted against the present petitioner. In that complaint case, the learned magistrate took cognizance against the present petitioner, where I have challenged the said order taking cognizance against the present petitioner on the ground that under annexure 4, my lord, at page 43, I have filed the birth certificate of the present petitioner.
Yes.
The date of birth is 4th September 2004. And the FIR registered on 6/4/2020, and the earlier date of occurrence is also 6/4/2020. And at the time of occurrence, the petitioner was minor. So the learned magistrate had no jurisdiction to take cognizance because he will be tried with juvenile court. And the cognizance has been taken.
Who is appearing? Notice was not issued, huh?
No, notice has not been issued.
issue notice, sir. We'll see, let's verify. Yes, the certificate has to be verified, issue notice, issue notice. To the state, yes. Next.
My lord, I prefer Muslim prayer, my lord, that,
It has to be verified, first of all, let us see, I am putting in 1 week after vote.
I am solving the copy.
Then counsel for the petitioner is relying upon the birth certificate of the accused. As per which item it is? Huh? 97.
My lord, in the charge sheet.
1 minute.
it is
Birth
mentioned
certificate of the accused placed in annexure 4, which indicates that the date of birth of the accused is. Where is the date of birth written here?
4th September 2004. Place of birth ऊपर था. 43 page 43. Place of birth ऊपर date of birth 4th September 2004.
Date of birth 4 September 2004. The alleged incident had taken place
On 6/4/2020.
6/4/2020. Therefore, the petitioner at the time of commission of offence was a minor, whereas ignoring this fact, the cognizance of the offence been taken against the petitioner by the court of law. By JMFC, Konark, by order dated 11/7/2020. The petitioner is challenging the said order on the ground that the JMFC had no jurisdiction to take cognizance of the offence once the petitioner is found to be a juvenile. Issue notice to the opposite party to verify the information.
So actually, kindly last to page 19. That is the charge sheet of brief factor.
I have issued notice. In the meantime, the petitioner is given liberty to move application for seeking adjournment before the trial court, awaiting the outcome of the present petition. Yes, next.
98.
98.
98. Defect number 13 is there, 1 week time.
Yes, cure the defect. Yes.
This may be issued to the vigilance because none of the vigilance council are also.
What is this defect is?
Number 13 regarding the prayer part, Lordship.
First, you don't know what prayer you are making and notice.
Lordship, in the matter arises out of a correction of charge. Initially, FIR was filed in the year.
Don't tell me what is the defect. Defect is your prayer.
Verify regarding that aspect, Lordship.
What's the order?
For correction of the charge only against that order.
Anyway, 1 week time is granted to cure the defect. Issue notice to the opponent. Yes.
Okay.
99.
The initially revision petition was filed challenging the order and praying for passing of the proceeding. Petitioner happens to be the husband. 306 case now is there. Now, I have also annexed the affidavit which is part of the police court record. We filed for the JMFC for the court below, wherein the informant filed affidavit saying that they don't want to proceed. That is one aspect of the matter. I will not say it should be passed on that ground. But one more thing I beg to point out to your Lordship, the father-in-law and mother-in-law and this petitioner are the accused persons in the court below. Now, may I just to your Lordship's kind permission file this judgment?
Who are you? You are.
I am the husband. I am not disputing that. I just beg to point out one thing, and I beg to also give this to my learned friend. I humbly pray your Lordship may kindly peruse the page, paragraph 19, page 14 of the judgment.
Yes.
My humble submission is no useful purpose will be sought by sending the petitioner to custody because nothing remains.
You are absconding.
No, I am not absconding. That I also explain. Just let me explain why I am not absconding. A revision petition was filed for reasonable court. A stay was granted. Unfortunately, the counsel passed away. The case got dismissed, which was not within the knowledge of the petitioner. When the police again sought for him, he filed. Instead of filing a restoration, he has filed a fresh case, and that has been disclosed in the petition. It is not a case of absconding, your Lordship. I beg to clarify humbly.
So show me the relevant portion. Is father-in-law, mother-in-law?
Madam, but the language employed by the learned trial court, I beg to point out paragraph
now the
19.
Question is whether the deceased was subjected to
paragraph 19.
Yes, 19, na 19.
Page 14.
Yes, I am reading there. subject to the husband, brother-in-law members, soon before the death in connection with the demand of dowry. And in this case, during the PW10, brother of the deceased and mother of the deceased have bore much important, but they have stated nothing supporting the results of the prosecution, which vividly stated about the mention of the father, the special evidence of PW brother of the deceased that they fully well with their husband and daughter-in-law member, and that there was no demand of dowry from Yes. Have you seen para 19? Read para 19. The brother of the deceased says that there was no dispute. His sister was gelling well with the husband and the in-laws. These are the kind of evidence which has come on record, on the basis of which the father-in-law and mother-in-law have been acquitted. What he says is, this is the kind of evidence which has come on record, qua the father-in-law and mother-in-law, subjecting me to the trial would be a futile exercise. What do you say?
Apart from that, there is a 2002 matter, and that tax sheet submitted shown the petition was absent of matter.
Absconding he is explaining. Absconding thing he is explaining. He says that some proceeding was pending, he got a stay, the stay was operating, lawyer died, got it dismissed and default.
There is so with that observation, my lord.
This is what his case is.
Paragraph 7, my lord. Mr. Rajkishore Naik passed away. That's a fact. My friend must be knowing it also.
Where have you explained that?
Paragraph 7, your lordship.
Para 7 of
my petition, page 4.
Yes. Para 7, huh?
My
yes.
ସିଏ ଚାଲିଗଲା ପରେ ସେ ଆଉ ପାୱାର ଦେଲେ ଆମେ appear କଲୁ
LCR
I have filed the certified copy of the judgment, not Xerox copy.
No, certified copy you have filed, but you want to read some evidence. Of any witness.
I am praying your lordship may consider my bail and I'll face the trial. There is a chance, but that is a futile exercise. Affidavit annexure 4 is part of police record. Someone needs affidavit file question, we don't want to prosecute. That is part of police record filed for the learning trial court. Annexure 4 to this
is the husband, madam.
Husband,
husband. See, the evidence is just suicidal. Okay. The witnesses are the brother and mother of the deceased. They filed an affidavit and we don't want to proceed. They went to the witness box when the mother-in-law, father-in-law was prosecuted.
Might be, sir.
Do you think that the same
the same witness may
no, para 19 you read. Para
evidence is required.
Para 19 he says
the deposition also.
Of the court,
husband, para 19 I'll tell you. PW10 brother of the deceased in cross examination of the deceased stated that the deceased sister was pulling well with the husband and the other in-law members, and there were no demand of dowry. This is the evidence of PW10.
But PW10 and 11 evidence is required.
He has been declared hostile by the prosecution.
We have verified.
He has been declared.
Okay, you verify. You place the certificate copy in.
Deposition.
Deposition and Mr. Samir Misal and counsel for the petitioner seeks 1 week time to place on record.
By tomorrow I will place it. I have all the copies.
2 days and least the matter next week anytime. Have you
deposition copy
and copy of the judgment and deposition shall be so. Yes, please.
State House next. Since your lordship has appreciated prima facie, I am praying. Next week,
where is the NBW?
It's now on my head.
Where is that order?
That has been issued. I have stated in my petition.
Where is the order? Show me the order then.
That is page 23. NBW has already been issued against the absconding accused Sudhakar Pradhan.
Page 23. Then I have to write right now. The petitioner is an accused in a fire number also. Along with the petitioner, the father and mother of the petitioner were also subjected, were also made accused. The father and mother of the petitioner, give me the certificate copy. Mother of the petitioner faced the trial. Faced the trial.
Arguing with the position.
The first additional session judge Khurda, while it's ordered while judgment dated 24/6/2024 in ST case number 106 of 2021, acquitted both the accused persons, namely the father and mother of the present petitioner. Petitioner's trial was split up. Legal counsel, Mr. Mishra, legal counsel for the petitioner submitted that he was not abstaining, rather he approached this court by filing a revision petition where there was a stay of the proceeding. Him. The stay was operating. Therefore, the trial, insofar as the father and mother of the petitioner is concerned, was split up. Eventually, the counsel who was appearing for the petitioner in that in the revision petition expired, and the petitioner had no knowledge about the same, no knowledge about the same.
In fact, he engaged a counsel to pursue the case. The counsel found that it has been dismissed. Then fresh case was filed.
He engaged a counsel to prosecute the case. Then he could discover that the petition which he had filed had already been dismissed in default. Subsequently, the petitioner, you are not now not apprehended. You are not.
No, that's because also
in the changing circumstances, on the basis of the present development, the petitioner has approved this court for seeking quashing of proceedings. Since the petitioner was absent before the court below on 4/10/2025, NBW has been issued. He seeks indulgence of this court for staying of the operation of the NBW till next date of hearing. In the meanwhile, Mr. Mishra undertakes to file the certificate copy of the judgment dated 24/6/2024, passed by the first additional session judge Khurda in ST case number 106 of 2020,
and the depositions also.
And deposition of the witnesses in that case. Leaves the matter on sir. Meanwhile, the execution of NBW issued against the petitioner by order dated 4/1/2005, passed by. Why don't you appear? You appear.
If a lordship will say on appearance, you will be released on bail, my lord. I'll be there.
No, you
will be put me inside, my lord.
If I'm considering, I'm staying it. You come, you satisfy me, then I may quash, or I may relegate you to trial court for.
Your lordship may now protect me, madam. I'm praying.
I'm staying it. Yes, staying till the next date of hearing. Lease the matter after 2 weeks.
Let's do that. Madam, I'll file it by tomorrow. A certificate copy नहीं जाऊँगी, तांको copy देंगे, तापर file.
Advance copy. Call.
चलो ठीक, copy टा दे दी.
160 na?
116. The other side maybe in the BC. And this is this arises out of a complaint case now. The sum total of the case is.
Who is appearing for the other side? Who is appearing for the other side? You are appearing? You are appearing for
okay.
Yes.
I pray only lordship next week, my lord. Next week. Some document is required, man. Only the power of attorney. Admittedly, there is a case, my lord. You have given check, my lord.
No. That is key check, right? It is negotiable.
Sir, 15 term by.
Upon who is it?
Sir, 15 term. Sorry, sir. Sir, 15 Sir.
Yes.
116.
Who is
appearing? Rajiv Ratha.
Rajiv Ratha was appearing. He was last time in BC.
Perhaps she must be watching the.
Then I will wait.
But that is better.
Anyway, I have to stay today until 4:30 because there is another matter also likely to be.
Please wait. I'll. Yes.
Item 100 to 102 milots, 10, 100, 101, 102 milots. There are some defects which are being reflected in the noting milots.
Why are you not creating you file on 23? You are not interested.
Milos, what has happened? It is inadvertent. We have not went through the
What
SR.
is this matter?
Milos, this is for quashing of the FIR, Milos. Milos, the defects are
What
with
is the status?
the defect is with regards to Milos filing of the certified copy of the trial court judgment, Milos. So your lordship may grant sorry, Milos, certified copy of the FIR, Milos. So Milos may kind
December 23 you
Milos,
filed.
I bow down to that. That
What
we are
will
at
you are not interested
we are
in
at
seeing?
default, Milos. I will not, Milos, make excuses, Milos. We are at
What
default.
is the stage now?
Milos, I will apprise you with this. What is the current stage, Milos?
I'm giving you 2 working days to cure the defect.
Milos, week, Milos, because we have to obtain the certified copy. You give me
Certified copy ignore. Forget about certified copy.
if your lordship are ready to move with
Yes. If you can argue, I'm ready to.
not today, 2 days later, then your lordship may keep it. I will move before your lordship.
In what certified copy in these are not appeal, these are original proceeding, and he is
Milos,
there.
only because it is of quashing, Milos, it has to.
He is already there. He will.
Okay. Milos may just keep it to day or after tomorrow, Milos.
But meanwhile, you try to
Milos.
cure the defect.
Milos.
100,
100, 101, 102.
100. There are 2 defects.
2 defects, 11, 18 and 18, 20.
22. What is that defect?
22 is certified copy.
And
18 is neat legible copies.
That at least you can do that.
Milos,
That
I
is
can do
okay.
that. Milos, I'll verify with the.
Defect 22. Something else.
No, Milos, I have the SR with myself, the list of SR 22 reflect.
Anyway, I don't want to waste time. 100, 102. Then counsel for the petitioner seeks 1 week time to defect. Let him do so. By which date? 1 week means give the date. If the defects are not cured, then the petitions shall be dismissed without reference to the court. If it is cured, please say it. Yes. 103.
May I please, your lordship. I have filed the aforesaid case note seeking to quash the FIR under Annexure 1.
Yes, sir.
But I have filed the aforesaid case note to quash the FIR under Annexure 1 at page 9.
Yes.
Your lordship may kindly see the FIR is registered at 7:30 p.m. dated 12/6/2023. Your lordship will get at page 10.
22:15.
Yes.
Yes.
Your lordship may kindly see Annexure 2.
2.
My lord.
Yes.
Annexure to the present petitioner number 1 has lost the FIR. Has lost the FIR. Petitioner number 1 has lost the FIR. Against the.
That is at 21:54.
My lord, your lordship may kindly see that it is registered at 7:15 p.m. at 12/6/2023. So the allegation is made.
Seeking quashing of the
First
file
one.
number 1.
I want to show.
That is registered at
12.
22:15.
Yes.
And you say that after you registered the FIR on
Yes.
21:54,
yes.
she filed that. That's what your case.
Yes. So your lordship may kindly
But
see.
both the case can go on together.
That's a different aspect. But fact remains that, my lord, though this FIR is registered against these persons because the father of the girl is one advocate concerned of the local bar, but therefore, my lord, the second FIR is registered. And your lordship may kindly see what is the allegation against the petitioner.
Investigation is going on in both the cases.
Investigation, but here, my lord, the POSCO Act is subsequently added.
But investigation.
Your lordship.
No, so they may drop.
Your lordship may kindly see what is the allegation against me. Your lordship may kindly see page 10. Your lordship may kindly see.
Yes.
यही कि मान लो सेकेंड पैराग्राफ यही कि आज दिन 4:30 समय मो झियारी संजना दास बयस 17+ अटे आसवाई आंभ घर को जीवा समय छकटारे अंबिका दास सारला दास भवानी महांती टाणी अंबिका दास सारला दास बोथ आर माय लॉर्ड लेडीज लॉर्डशिप में काइंडली सी बोथ आर लेडीज भवानी दास भवानी महंत डॉटर ऑफ गिरिजा शंकर दास एंड सारला दास डॉटर ऑफ गिरिजा शंकर दास बट बोथ आर भवानी सारला बोथ आर लेडीज योर लॉर्डशिप टाणी चुटी को धरी घोषारी दे पिटिले Oh, Ambika Das, such and such, whatever allegation is there, it is against Ambika Das, and he was arrested and he was released on bail. That's it. Chutti ki dhari pitile. You Lordship, may kindly see what are the FIR registered. You Lordship, may kindly see 341, 323, 294, 354, 354B. We are ladies, Your Lordship. We are ladies. 307, 506.
Well, yes, what is the stage? The allegation is something you are registering the FIR in almost all the offense in IPC.
307 is there, my lord.
Like, what are the allegations? Just see allegations.
Yes.
Ambika Das.
354 clearly, my lord.
354 ladies can 350
That's right, but this is registered after immediately. This FIR was registered at the time. Just see the timing.
Yes, timing.
22:15.
22:15.
Okay. And the earlier FIR he has filed against you 21:54.
Not a chow.
Immediately.
Yes, my lord.
But
After the 20.
I don't want to comment, but what is the investigation?
So I have to attend
You are protected, na?
No, I am not protected. I am not protected. You Lordship, the both are ladies. That is POSCO Act. You Lordship knows that. Whenever POSCO Act is there, it is added, whoever may be.
No, not like that.
Oh, that is the impression.
Not like that.
You Lordship, no coercive action shall be taken.
In this case, there is POSCO. There is no POSCO.
No POSCO, but subsequently it is added. I have stated, Your Lordship. Your Lordship, may kindly see.
Where is that? The investigation is still going on.
No, but they have added.
Where have they added?
But whenever madam, the Pinto was arrested, madam, POSCO was added. Whenever Your Lordship, may kindly see page para 5 of my petition, page 4. Initially, FIR under Annexure 1
was. What is the stage? You tell me. I'll put it on Monday. No, Monday, because otherwise, if you can't tell, then I have to protect.
Then
Monday. Therefore, I'm not. I'm simply you tell me what is the stage. I have to protect them, because it seems this girl was planted. Monday, yeah. Monday. Let it be Monday. Let us see what.
No coercive action till then.
Monday, therefore I'm keeping it Monday.
Yes.
Otherwise, Monday, if I find it, I'll protect you and
deploy it.
Because the difficulty is anticipatory bail generally in POCSO he will not get. And this apparently looks like a false case. Whatever, false case. So investigation will reveal. So I have to protect. Simple. Yes.
104.
Deploy.
Yes. Non-APS in the interest of decision. Yes.
105.
May I please penalty? And the petitioner files his application for passing of a cognizance as well as proceeding manner. Kindly have a glance to the Annexure 3. The FIR lodged on 7/5/23 for commission of offence for 17/94 323 506 and a charge sheet submitted self-same offence manner.
Yes.
There are commission of a charge sheet. The informant opposite party number 2 has submitted written representation before DIG Tarche, making same allegation.
Yes.
Thereafter, the charge sheet already submitted and a cognizance has been taken for commission of offence under 3762 and a 470 372 of IPC matter. 370 and 372 matter. And same occurrences, 2 FIR has been one have filed and some charge sheet submitted. Thereafter, after submission of charge sheet, she filed an application before claiming that the police has not taken a so kindly peruse my lord.
Where is that?
Page 11. The FIR subsequent FIR matter.
First FIR was?
First FIR Annexure 3 matter.
Annexure 3.
Yes, madam.
Yes. That was investigated?
Investigated and some charge sheet.
Charge sheet filed. Charge sheet filed on the same provision.
23/5/23.
Yes.
FIR lodged on 7/5/23.
Thereafter another FIR.
Yes, 17/6/23 minor. 23/5/23 charge sheet And after submission of a charge sheet on 17/6/23, she has made a representation before DIG, alleging that
In that case, earlier FIR, there was no 376.
no, madam. First FIR 376 nothing. On our representation 376 has been added and charge sheet submitted.
Okay.
Yes.
And what is the second FIR which you are
Second
seeking?
FIR phase 11, madam.
11.
Yes, madam.
Yes.
5 ବର୍ଷର ବିବାହର ମିଛ ପ୍ରତିଶ୍ରୁତି ମୋ ସହିତ ଏବେ ମୁଁ ଶୁଣିବାକୁ ପାଇଲି ବଟମ ଅଫ ଦ ଫାର୍ଷ୍ଟ ପାରାମାଇନ ଏବେ ମୁଁ ଶୁଣିବାକୁ ପାଇଲି ଆସନ୍ତା ଅଳ୍ପ ଦିନ ପରେ ତାଙ୍କର ତାଳଚେର ଆଉ ଗୋଟେ ଝିଅ ସହିତ ବିବାହ ହେବାକୁ ଯାଉଛି and thereafter ଆଦିତ୍ୟ କଳସ ମୋ ଜୀବନ 7/5/2023 ଏକ ଲିଖିତ ଏତଲା ଦେଲି ଏ ଲିଖିତ ଏତଲାକୁ ଭୁବନ ଥାନାର ଆଇଆଇସି ସୌଭାଗ୍ୟ ସ୍ୱାଇଁ ଗ୍ରହଣ କଲେ ପଢିଲେ ଏବଂ ସଙ୍ଗେ ସଙ୍ଗେ ମୋତେ କହିଲେ ଏହି ଏତଲା ଚଳିବ ନାହିଁ ଏତେ ଷ୍ଟ୍ରଙ୍ଗ କର ନାହିଁ this is the fabricated story ମ୍ୟାଡମ ଏଟା ଲେଖିକି ଏଫଆଇଆର ଦେଲେ
Yes, sir. What do you say? Yes.
370 is not there.
No, thereafter, after investigation, charge sheet was filed in 376.
No, madam. First FIR charge sheet ହେଲା ପରେ it was the fabricated.
In the first FIR, whether 376 was there?
No, madam.
But in charge sheet it was there, na?
No, madam.
In first FIR, no 370 is there, madam. Charge sheet also no. In second FIR, madam, he is saying charge sheet there. No, madam.
But incidents are same. Because one provision was left out, so by improvising you have given.
Then Milord. In second FIR, charge sheet is there 376 Milord. Both the FIR may be clubbed together and one trial Milord.
That is the only thing. But passing can't be possible. Passing is not possible. You can be tried. Both the cases can be tried.
Yes.
I guess offense is not made out.
Oh, that is a different story. Whether made out or not, that will be tasted there. I am not tasting. I am not tasting that. I said that see the allegation in the first FIR and allegation in the second FIRs are different, but pertaining to same incidents. So the trial should go together. Simply issue notice. Simply issue notice to opposite party notice. Returnable within 2 weeks. Yes. That's it.
106.
Is there any judgment?
Yes, madam. Each one of bahagar is se tara alga bahagar is ye bhi alga
Or maybe she may not prosecute.
time petition that will be granted, madam.
Huh?
And the date fix is the petition file time petition that will be considered, madam.
No, later come after 1 week. Then this matter will remain for another 5 years. Bring here. I'll try and quash it.
6.
Yes.
Same, madam.
6, huh? Same. Issue notice returnable within 1 week. Huh? At least after 1 week. File the requisites.
Yes, ma'am.
Immediately. Yes.
108.
2 working days for 5 minutes. Along with the other part, 2 working days.
Interim order is there.
There is no interim order.
Why have you not filed requisites? If you want of requisites, notice to opposite party number 2 and 3 and could not be issued by way of last and final opportunity. 1 week time is granted to the petitioner to take necessary steps to serve opposite party number 2 and 3. Release the matter. Last week.
1 week.
October, but matter will go to the October last week.
39.
May I please? Petitioner file application for order dated 13/8/2024. That same day, the submission was wrong submission made by the Vigilance Department. The appeal has been against the appellant, abated against the appellant. Since long 2009, the IA has already been pending.
See,
the substitution.
Sole appellant has died.
Yes.
It is
Substitution.
abated. Now you have already moved application. The abatement is recalled.
Substitution.
In fact, in the last occasion also, they should have pointed out this. They didn't.
No,
point
no,
it.
they,
Substitution.
whatever.
Anyway, I will
Pending.
set aside the abatement and.
Yes,
No,
madam.
the difficulty is that she says that the leave to continue the appeal had already been filed.
That's right. It was escape notice. I will allow this
Yes,
application.
yes,
Unnecessary.
yes.
Yeah, right now. By the order dated 13/8/2024, appeal has been abated on the report of the Superintendent for Police Vigilance, Sambalpur, that the sole appellant has expired. However, by that time, by that time, the LR or wife?
Wife. Widow.
Widow of the appellant had already moved an application under section 394 CRPC seeking leave of the court to continue the appeal. In view of the reasons stated in the application, that the IA number 600, the same is allowed. Memorandum of parties directed to file within a week. This is the matter in the weekly list for hearing. Yes.
Well, it's two items can be disposed of. We have received the instructions. Item 2, Malets.
Item 2.
Yes.
Yes.
CRA 426 of 94. The appellant is no more. He died on 27/5/19. SP Barampur.
SP Barampur Vigilance. SP Barampur.
Item 19 minutes.
1 minute. 2. Item 2 first.
Yes, minutes.
Died on. The appellant died on
27/5/19.
27/5/19. Stands abated. Okay.
Yes.
Next.
19 minutes. 19.
19.
CRLA 344 of 2006. Date of death is not ascertained, but he is no more, minutes. SP Barampur.
SP Barampur Vigilance furnished the instruction to Mr. Rajvi regarding the death of Kishore abated. Yes.
Yes, ma'am. That's it.
Yes. Next.
110 and 11.
11. Miss Marana is not well.
See, what has just 111 ta khali koi deta hai. 111, my submission herein is that there is an arithmetical error in the judgment.
That I know, I remember.
By which have been convicted.
But he has to.
If that is rectified, then the appeal is to be allowed.
Okay. Mr. Marana, counsel for the vigilance, is indisposed. Hence, a request is made for an adjournment, and this is the matter.
The orders.
After we.
Orders.
Next. 112.
112.
Your Worship, item number 112, I have filed this IA for correction of a typographical error.
112, huh? What about one item, one and all? These are fresh matters. Yes. Yes.
Your Worship, I have filed this IA for correction of a typographical.
What error?
Your Worship, in paragraph 1 and 6, inadvertently it has been written that.
Order it has been mentioned. Your discharge.
No. Which order correction you want?
17/10/2023.
17?
10/2023.
112.
My
112.
Wrongly it has been inadvertently mentioned cognizance order because another collector matter was there. That is
Which order you are talking about?
17/10/2023. First.
This is Prabhakar Naik.
Yes.
17.
17/10/2023.
17. Where is that order?
that the discharge petition has been filed, they have to reject it thereafter.
But this revision petition was allowed.
Yes, my lord. Cognizance had wrong. Inadvertently, it has been mentioned cognizance order.
But this I have allowed on 30th July 24.
Yes.
In that order, there is a mistake.
Yes.
Where, which paragraph?
Paragraph 1, my lord.
Paragraph 1.
The Lordly Special Judge Vigilance Court by the order dated 17/10/2023 in TR case number 2 of 2014, cognizance, discharge.
Oh, discharge.
Yes,
okay.
that will be
Para 1,
yes,
ये 16/7/2024 order में judgment sorry judgment 30/7/2024 judgment रे first paragraph से cognizance लिखा है discharge cognizance discharge. There is a typographical error occurred in the judgment dated 30th July 2024 in paragraph 1. Cognizance order has been mentioned in place of discharge. Discharge. Okay. Yes.
Paragraph 6 also.
6 also. Para 6 also. 6 also. ठीक है? Cognizance order is discharge. Okay. Thank you.
13
Yes.
140.
Be also same. 13 to be same. Cognizance order of cognizance order of discharge. Yes.
My lord, so far as the compliance affidavit is filed, my lord, I have to humbly submit before your lordship is that the entire service, in spite of the order of this honorable court, my lord, the entire service period of the petitioner has not yet been regularized, and his consequential service benefit has not yet been sanctioned, and his service book has not yet been made up to date in order to enable him.
Have you filed the?
Yes. Filed a compliance affidavit.
My lord, earlier also.
After 28/6/2024. 28/6/2024.
Yes, we have filed.
Yes.
With regard to that compliance.
Can I have a glance, my lord?
Filed an objection, my lord. And in their objection, my
Don't stretch the contempt petition to that level. It's substantial compliance, no contempt. Show me.
How they
I can't keep on adjudicating things.
Milord.
Contempt petitions are not adjudicating process.
No,
it is only to be seen whether substantial compliance.
Adjudication, my lord. That order has been complied.
Show me.
Declaration of service.
Can I have a glance, milord? OP number 4, milord. So was filed by OP number 4.
Yes. Flag.
Milord?
OP number?
4, milord.
Flag.
Engineer in Chief, Rural Water Supply, milord.
Number 5. Yes.
First, milord, page 7.
When have you filed?
We have filed, milord. I'm file ko
1/8/24.
1/8/24. Yes, milord.
No, when I issued frame the notice on 20, when I framed the notice?
24/7, milord.
I see. I framed the notice on 28/6/24. Okay.
Yes.
Yes, thereafter you filed. Okay.
Kindly have a glance, milord. Annexure, page 7, annexure A/4, milord.
A/4.
A/4, page 7.
A/4 दिखाना चाहते हैं क्या है? OP4, yes.
Milord. Annexure 7, milord. Annexure A/4.
This one.
Is, milord, filed by Joy Naran Seat.
Joy Naran?
Seat.
No. Nursing 9. Joy Naran Seat.
Milord.
This is a different thing.
Milord. Page 7.
No, this is earlier. Yes. Page
7, milord.
7 of the affidavit.
Of OP number 4, milord.
Yes.
Can I have a glance, milord?
A/4, huh?
A/4. What he has received, milord? First, provisional pension 31,000 some odd, milord. Second, provisional pension 22 lakh some odd, milord. Third, unutilized leave salary, my lord, 3 lakh some odd. Total, my lord, 31 lakh 13,857 he has already received, my lord. Then, my lord, kind of a glance. Next annexure, annexure E by 4.
Yes.
What he is saying, my lord, regarding pay fixation, my lord. Annexure E by 4.
Fixation, my lord.
E by 4. Kindly have a glance. As per the OCS pension, page 13.
13,
13.
Yes.
Annexure E by 4.
Yes.
OCS pension rule form so and so.
Yes. Column
One page, my lord.
13, I understood. Which column you are reading?
That is one page, my lord. Total six column, my lord.
Which column you are reading?
I am reading, my lord, first column, my lord.
Name of the pensioner.
Now, in suppressor so and so, finance department notification so and so, dated in order to comply court case, sanction is accorded for payment of revised provisional pension, my lord. Provisional family pension commuted value so and so, as indicated below, of Sri Narsinga Naik, pending issue of final PPO by the accountant, my lord.
Yes.
So, and his pay has been fixed to 26,548, para 5, column 5, my lord.
Yes.
Then, my lord, page 15.
Yes.
Office of the contender to the petitioner, my lord. What he is saying, my lord, he has not, that the second RSCP has not been added, my lord. That has been clearly mentioned, my lord. Upgradation GP 5,400 with effect from 1/1/13 has been added, my lord.
Yes.
Then, my lord, comply affidavit of OP number 2. OP number 2, my lord. Page 14.
Yes.
Page 14, my lord. Office of the Municipal Council, Bhavani Patna. To the Superintendent Engineer, Nuapada.
Page.
Page 14 of OP number 2, my lord.
Yes.
Flaggy.
Yes.
With reference to letter on subject side, I am to bring to your kind notice about fact that Sri Narsinga Naik was working as a junior engineer in his office from 25/4/95 to 20/11/97, and he has been paid advance for differential work. Accordingly, a sum of rupees 87,460 is lying on outstanding against him. So the NOC in favor of him cannot be issued by this till adjustment of the above outstanding advance. So far as the regularization of the service of Sri Naik and sanction of foreign service term and condition is concerned, my lord.
Yes.
So, my lord, admittedly, my lord, he has received some 31 lakhs, some odd, my lord. Thereafter, he is saying he is getting provisional pension, my lord. Final pension has not been done till date, my lord. So, they are waiting, my lord, for this, my lord.
Why final pension is not been done?
He has to submit the NOC, my lord.
Yes.
Taken the 87,000, my lord, that has not been, during that period, that have not been adjusted.
But he says that NOC has been given.
Who did
Long and short of this issue is
They
this.
are not
Milord?
going for the paper
Long and
file.
short of this matter is he has supplied all the document with you. Still, you are not processing his paper for pension.
No. We are processing, my lord. We are waiting for the NOC, my lord. After receiving from NOC, immediately we will give his final pension, my
Where
lord.
is the NOC?
My lord, in NOC, I have
Show me.
in the my lord, that's why I am submitting, my lord. Yes, they, my lord, after filing a contempt petition, they filed a show cause affidavit. Thereafter, I filed an objection. In that objection, kindly be glance to NOC, my lord. That is annexure.
Yes.
What NOC देखिए?
My lord.
ये तो देखिए काट लिया NOC.
16, my lord.
16?
Charge paper, yes, my lord. 57, charge paper I have submitted.
16 charge
Yes.
paper, yes.
Yes, my lord.
Hmm.
And so far, my lord has, that's why directed for personal appearance. So far, after I read the annexure 13, my lord, there is
Yeah,
any.
you don't jump. Show me that 16 charge paper. Where is the NOC?
My lord, NOC they have to obtain NOC, my lord. I have submitted charge paper. Yes, my lord.
You will not discharge that.
So far as NOC, yes, I am reading.
Last time also it was argued for 15-20 minutes. The only issue is who.
Last time, Mr. Lordship was querying that thing that also I was saying that in the time.
Let me complete first, my lord.
12 lakh something or.
Who is supposed to give NOC to whom?
Yes. NOC, my lord. That is working under the junior engineer.
Where from will get the NOC?
Executive officer, Bhavani Patna municipality, my lord.
He is not working under you.
My lord.
He is not under you. He is under you. He
Yes,
is
sir.
working under you.
My lord.
He is working also under you.
No. What really? Working in junior engineer's office from 95-97, he has been paid advance rupees so and so.
Only to that effect there should be an NOC so that his paper will be processed.
My lord, only.
And the question is who is going to issue that?
Who is going to issue the NOC?
Who is that? Who is going to issue? Your officer.
Office of the Municipal Council, Bhavani Patna.
Why can't it be done by your officer? They are under you. You can ask for NOC from them. What is this going on unnecessary?
My lord, let me
Yes.
submit, my lord. I have filed in both the cases, my lord. That has not been listed. But before that, I have earlier also they have filed 2 complaints affidavit, my lord, to mislead this honorable court, my lord. And they are thinking that it is a mockery, my lord. And so far as pension is concerned, I am reading, my lord. They have not gone through the papers.
You process the
what I have
pension paper.
submitted.
That's all. You
The
process
head
the
of-
pension paper. That's all.
The head of office shall prepare the pension paper on the basis of qualifying service determined.
And you see,
by
last
his-
time, 1 minute. Last time also it was argued. You have said the same thing. NOC is not given, so therefore we are not going to process pension papers. And you get the NOC. Otherwise, let appear before this court. Who is the contemner?
My lord, only my-
Who is the contemner? Who is the contemner? Let him appear in person.
My lord, let him, my lord. One thing, my lord.
No, I can't waste time like this.
No, what?
I have already framed notice for
No.
contempt. Let him come and appear.
No. What I'm submitting, my lord. He has filed an objection, my lord.
What?
He had filed an objection, my lord.
Yes, then. No.
Then some time to my reply, my lord.
This is, you are stretching enough. See the voluminous papers. Contempt proceeding. Why pleadings after pleadings?
My lord.
Then
You complied. That's all.
Then, my lord, let it come next week over telephone. I'll obtain instruction, my lord.
No, you
Next week.
let him appear in VC.
Only next week, my
The
lord. Only-
contempt,
Yeah.
by the order dated 28/6/2024, this court has already issued notice of contempt to the contemner.
Lordship, contemner 1 has been changed. Last occasion also amended that name. Usapati has been added as the OP number 1.
Whoever who is OP number, who is OP number 2? It's not necessary that the
OP number 2 is filed the complaints affidavit.
Admitted, my lord. They have.
Who is? You want completion of this proceeding or will keep on going? Who is the OP number 2?
OP number 2 declared.
Yes, OP number 2, my lord. OP number 2.
Chief engineer.
My engineer in chief public health, my lord.
Yes.
Let him appear. Let him appear.
My lord, he is doing all mischiefs, my lord.
I'll answer it.
Monday.
Yes, Monday.
Monday, I don't want anything. I will not only ask for personal appearance, I'll take strict action. What is this going on unless Monday?
My lord, only I would like to submit one word only from their counter, my lord. A complaint affidavit.
Sir, I am not going to waste time like this.
My lord, that has not been complied.
It's all right.
Benefits due to the petitioner will be paid accordingly. That has been written. They have written, not gone through that paper, my lord, and submitting falsely.
Monday. I have, this is very, see, so moto contempt. Orders are being passed long back. And so much of contempt is taken. Even then you are not doing it. What is this? You give no objection, he will say, you will give no objection. What is this? Otherwise, you amend the memo of parties, huh? By Monday, so that I can ask for appearance.
I will file a memo accordingly.
During the course of the day, let the counsel for the petitioner seeks to memo of parties during the course of the day. He may do so. Leave the matter on Monday. Yes.
I may be permitted to correct my lord here, my lord.
You type it and give it. Yes. Yes. 15.
Only name is there, my lord. All are there. Only name should be inserted instead of. That's why.
Allow. Yes.
15.
Yes, sir.
Yes, my lord.
To 1 week time be granted, my lord, so that I'm for number 2, my lord.
You are now appearing.
Appearing, my lord.
OP number 2, pursuant to the note, pursuant to the order dated 2/5/2024, notice was issued to opposite party number 2. So and so enters appearance and
My lord, till then, 1 week time. There may be stay.
Till then, there may be stay order.
Stay.
For the proceedings.
Here I had not given the stay. Now opposite party number 2 has come to oppose you.
17, that means
I'll be reach it immediately. What is this matter? Can
my lord, my lord. I am the complainant, my lord, in court below, my lord. Petitioner, my lord, he happens to be the owner of the property. And opposite part number 3 is the power of attorney of the petitioner, my lord. So through power of attorney, a property was sold to me. But because it could not be recorded in my name, that's why he wanted to return the money. Return the money, my lord.
You don't want money.
I wanted money, my lord. He had given it in the shape of check. That power of attorney holder, my lord. He had given in the shape of check, my lord. That was the reason, my lord. I had filed a complaint.
What is the check amount?
3 lakh. 3 lakh rupees.
Why don't you give?
Actually, the petitioner has not issued the check.
All these things forget. It just wanted it. See, you notice was issued to you under 138.
My lord.
You have replied.
Notice was not issued to me.
Complaint. Show me the complaint.
One notice has been issued.
Show me the complaint.
One witness have been examined, my lord. Complaint is, my lord.
Actually, I am not
my lord.
The only my point is that I am one signatory to the impugned check.
Then you will be acquitted. Why should this is quashing, huh?
Yes, quashing.
Why should?
I have to face the proceeding. The proceeding is against actually OP number 3. How? He has issued the check.
He is a power of attorney holder, my lord. He had given the check. But the money is because he is the owner of the property, my lord. Petitioner is the owner of the property.
The problem, what he says,
Even if there is any such
he says he is the owner of the property.
Yes.
He has given power of attorney to opposite party number 3.
My lord.
And he had taken the money and power of OP number 3 has taken the money. And he has given a check. So therefore, why should he face 138? That is what he says.
Because my lord, though it is the property is sold through the PW3, OP number 3, my lord, power of attorney holder, but the entire money will deem that entire money goes to the owner. Maybe power of attorney holder for the sake of, my lord, only for the time being.
So what is the legally recoverable debt is recoverable from the power of attorney holder only.
Power of attorney.
Yes.
Not
Check is delivered, but liability is both the liable, my lord.
Liable, how will you say liable? He has not issued the check. You can prosecute the person who has issued check on behalf of someone, suppose. That is their internal understanding. Their internal understanding between this thing. Why are you after the original owners? That is why I issued notice. But ultimately, you are the beneficiary. Why don't you pay the money? What is the problem?
The question is that that is different. Even any such liability, he wants to appeal.
Technically, you may have a case, but you have taken the money.
I have not.
Your power of attorney holder has taken the money.
Let them file a counter.
No, I'm sending it to mediation, pay the money. Otherwise, if I'll quash, then his money will never be recovered. You keep on fighting for years to. Why don't you
No,
take
I'm
for?
not pleading for.
You are for OP3.
No.
OP3, who is for OP3? Notice has been issued to OP3.
Yes, ma'am.
Nobody is appearing.
Both
You are appearing for petitioner.
The petition.
For OP3.
There is nobody for the OP3. OP3 has not appeared even if he has received the summons. Notices.
Then you know what is happening. You know, this is a case of complete cheating. Deliberately, OP number 3 is not appearing. You want it should be quashed. Then he is left to on the left.
If your lordship permits me, then I can issue another notice.
Bring OP number 3. Otherwise, I'll not quash.
Then I may be permitted to take notice once again for the OP number 3.
Have you filed the requisite? OP number 3 service.
OP number 3. OP number 3 might have received.
OP number 3 is the main service complete. No, process has gone. Either you pay or I'll dismiss. This is
OP number 3, I will take notice against OP number 3 once again.
no, I'm sending you to mediation. You try and come. Meanwhile, you can very well, you know.
My lord, that may be.
I'm sending you to mediation right now. Petitioner, the petitioner has been prosecuted by opposite party number 2 for alleged offence under section 138A9, along with the opposite party number 3. How many petitioners?
Petitioner 1.
Petitioner and opposite party number 2, opposite party number 3 are being prosecuted by the opposite party number 2 for alleged offence under section 138A9. It is alleged that the petitioner is the owner of the property and had given power of attorney to opposite party number 3, who indeed entered into an agreement for selling the property to the opposite party number 2, opposite party number 2. Since the
Sold the property.
sold the property to opposite party number 2.
Sold the property, but it could not be recorded in his name. So that was the condition, my lord. If it is not recorded, this will be refunded back the money.
Certain non-compliance of the
condition.
non-compliance.
My friend is misleading you.
1 minute. Non-compliance
That's
of
a complaint case.
terms of the sale condition. The sale could not be successful. Therefore, the sale consideration, which was given by the opposite party number 2 to opposite party number 3, has been returned through by way of a check by opposite party number 3 to opposite party number 2. Opposite party number 2. Since the same check has got dishonored, the opposite party 2 has issued notice to opposite party number 3 as well as the present petition. The petitioners have challenged the proceeding initiated against them under 138A9 on the ground that neither the petitioner has issued the check, nor he has any lien with the opposite party number 2. Opposite party number 2. issue notice to opposition number 3. Issue notice to opposition party number 3. Since the matter is arising out of a dispute under section 138 and 8, I feel it appropriate to relegate the party to the mediation center, High Court Mediation Center. The coordinator of the mediation center is directed to fix a date for exploring the possibility of settlement amongst the party. The coordinator shall issue notice fixing a date to all the concerned parties, and after the mediation, place a report before this court. Release the matter after 3 weeks. 2 weeks. Yes. And you file the process for opposite party number 3. Meanwhile, mediation will take place in pay the money or otherwise we'll see whatever. Yes.
Till then the matter may stay.
It is there all. No. Yes.
Number 16.
May it please. This arises out of a complaint petition.
Yes.
First from the short death chat, your nursing kindly have a glance.
Yes. Yes.
But instead of taking your nursing fees, these are all admitted facts on record. Cause of action for filing this complaint case, as stated in complaint petition, is that the petition was engaged a transport contractor on a work order passed by by the company to which the in which Suresh Kumar Agarwal, the petitioner number 1, was the erstwhile managing director.
Okay.
But admittedly, this case, he says that they were supplying the transport supply was being carried on. They were carrying the goods, and they were being paid from time to time, through RTGS, for which a ledger account is maintained, and the ledger account is maintained for last 11 years.
Okay.
Then there is some dispute about some amount of the money. Because we say that it is a transit loss, he says that no, there was no transit loss. That only a purely question of fact. I will not take your lordship. My first contention is, my lord, that in
Suresh Kumar Agarwal was a managing director. What about Manish and Saket? Manish and Saket.
They are non-executive directors.
Directors, okay. Yes.
The admitted case is that these 3 persons had never any direct contact with the complainant.
Resigned about 6 months before that.
And the cause of occurrence, as alleged by him, prior to that 6 months before, I have resigned, and the company register was intimated duly by the
32 form and all.
32 form. I have given those copies of that. Right. But first contention is your lordship, if your lordship will kindly appreciate. But in order to bring in the ingredients of the 420 law, there must be the intention right from the inception of the transaction.
Right.
If you have been transacting me with for last 11 years and I have been receiving money, and then subsequently
part of the money is not received,
part money is not there,
then there can't be any intention to that.
That cannot be any intention. That is my first point, my lord.
Yes.
My lord, then also they have filed. My lord, your lordship, page 2, your lordship may kindly have a glance.
But who will represent the accused company? MSP.
MSP.
Notice by institution, the management will take over. The insolvency.
Now the new management is taken.
This opposite party also made a claim there. They filed a IVC. My lord,
Say
sir,
that page 2 your lordship.
Okay.
the mandatory the demand notice was to be made. In that was the
My lord,
Who
they have-
initiated section 7?
My lord,
Who initiated section 7?
section 7 is the
complainant.
complaint.
Is a financial creditor.
My lord,
Being a financial creditor.
KPS logistic.
No, being a creditor or operational creditor.
Being a claimant, my lord.
Must be nice. Section 7 must be financial creditor.
Financial creditor.
That bears a
Financial.
financial creditor.
Yes.
Okay.
There in the complaint petition, that insolvency proceeding petition I have given. He says that out of total 2 crores 57 88 lakhs 88,062 rupees, and he has received all the money except 56 lakhs 78,837, which is the bone of contention. Then, therefore, I have given my lord relied on page 3 several decisions of the court, apex court, my lord, to state that if the intention is not right from the beginning, then case cannot be made out under section 420. Then, my lord, the next point is that
Are you willing to pay on installment or whatever?
My lord, I am not there, my lord, anymore with the company. Company has been taken over by third-party management, my lord.
Whether his amount, that 58 lakhs, is part of resolution plan.
They filed a claim. My lord,
What happened to that claim?
That RIP was appointed. So the NCLT court directed them to file the claim before them.
That's what I'm asking. Where is the plan?
Right.
Show me resolution plan.
Resolution plan I have not annexed, but their objection itself they have mentioned. Their objection filed.
You tell me what is the resolution plan?
Resolution plan we do not have.
I don't have.
Whether this amount is already factored into resolution plan or not, I'm asking.
Lord,
That is the main issue. After you suffer a proceeding under NCLT, if the amount for which the case is registered has already been factored into section 7.
It's noted, my lord, from the, I have filed a written objection in this case, my lord, the opposite party. They have stated therein, my lord, that it is true that the present opposite parties initiated an insolvency proceeding before the NCLT Calcutta bench under section 9 of the Insolvency and Bankruptcy Code, and the said matter is sub judice before the learned tribunal, arising out of a separate cause of action and has no bearing with the present criminal.
That is general statement.
Moreover, demand under the Insolvency and Bankruptcy Code by the present opposite party demanding payment of rupees 96 lakhs 77,983. Then, my lord, in the present ICC case was instituted prior to the proceedings before the NCLT Calcutta, since the petitioner along with the company intends to fraud the petitioner since 2018.
Who was the RA?
No?
Resolution is successful. It's approved. Who is RA?
The details are not with.
Oh, these are the material facts you have to bring, because these are changing circumstances. On that basis, I can quash it.
Next
you tell me who is RA, whether this is a financial creditor or not. If it is a financial creditor, whether in resolution plan, whether this amount is factored into or not. If it is factored into and a new management is taken over, then the liability goes straight away.
The management professional.
So what is his finding?
I will furnish a copy of the resolution.
You get that. And who is RA? Who is taken over now?
There is some Rosmi Metallics Limited. What
Rosmi
I have been told, Rosmi.
We just see whether the RA has already taken over. Already taken over, and what is the resolution plan? Whether this amount is factored into or not. These are his objection is general objection. Both the things can go together. That is just like civil proceeding and criminal proceeding can go on together. Everybody knows it.
He doesn't deny that this amount is there in his.
But if you have realized the money there and it is factored into the resolution plan, then nothing survives.
With respect and
Perhaps that is the reason he is not there.
with respect and humility, my lords, actually, I would like to submit. Actually, our petition, Mr. Suresh Agrawal, who has been petition number 1, he resigned from the office of director months before. Number 1. Number 2, Manish Agrawal and Saket Agrawal has been appointed day back as non-executive director.
There you may have a difficult because 32 form and all repeatedly Supreme Court has also said this is a matter of trial. When you resigned, when you submitted and all. Why are you getting into all this thing? I am giving you a shortcut. You show me the resolution plan, I'll get into it and do it. Unnecessary, why should you get into all these things? Then there are
take some
set of
time.
judgments.
I'll take some time, my lords, because the other company has taken over. They have to trace, they have to get the.
Therefore, in changing circumstances, we can very well.
Only the resolution plan, copy of the resolution.
Yes. Non-APS for opposite party, matter partly heard. Least the matter for further hearing. Meanwhile, counsel for the petitioner undertakes to file the resolution plan. A resolution plan which has been approved by NCLT. NCLT while resorting to initiated by the complainant opposite party.
Not one petition was there, but the resolution has been made by bankers.
And he was one of the claimant, na?
He filed a.
Who has initiated Section 7? I am asking you.
Financial creditors.
Resolution proposal.
He says that I have filed a demand.
I think you don't have that instruction exactly.
I don't have that.
Resolution plan. Release the matter, entry order to continue.
Let us see what is there in resolution.
Entry order to continue.
The demand claims include.
That's what I'm saying. It is factored into in the resolution plan. Then the scenario is different altogether.
Right.
Okay.
Right.
We will need not go to those factors, resigned or not resigned, whatever. The company, the management is taken over by someone else now.
But that happened during the proceeding of this.
Interim order to continue, you do it immediately so that.
So next date.
Yes. Interim order to continue till further orders. Yes.
170.
Adequate time may be given because.
3 weeks up. 3 weeks up.
4 weeks.
4 weeks. 4 weeks.
Public.
170.
The FIR which has been lodged. This has to be urgent because Mr. Maharana is appearing for the side. He is not well.
My lord, may I have a glance to the earlier order dated by 22 April 2024.
For adjourning?
No. On that day, my lord and friend assured that within 3 months we can submit the charge sheet. But my lord was pleased to give them 1 month grace.
But
to my instruction.
That perhaps the reason he fell sick.
Exactly.
Next week.
My lord,
not well.
Next week.
Next week.
Obliged.
118 may please, my lords.
Yes.
Let's get the petitioner is challenging the order of cognizance, my lords. Let's it is arising out of 1cc case, section 138 of NI Act, my lords. If your lordship,
You are the accused.
my lords.
Yes.
I am for the accused. But if your lordship may kindly.
Notice was issued.
My
Opposite party number 2, the notice.
Notice was issued and interim stay also granted. The 1cc case belong to the 2005 and this case has been filed in the 2022.
22, this matter is pending. What is this matter?
My lords, there is a tender for lifting for molasses, my lords. And the petitioner here has succeeded in bidding process and quoted an amount and deposited some amount. There is a cash security, my lords. Then there is an outstanding amount. But in the meanwhile, before taking cognizance here, the petitioner has cleared all the amounts. To that effect, I have the checks I have annexed in Annexure 4 series. All the amounts have been settled in the meantime. Nothing is outstanding. For that, there is an interim order and notices have been issued.
Why he's not coming?
No, my lords.
What is happening there in the trial court obviously?
My lord.
Might be the reason that he has received everything, he's not interested to proceed.
My lord.
Bring him, he's your friend. You paid him.
My lord.
Shall I send it to mediation and interim order will continue, bring him and
It is better, man.
better.
It is better. Then ultimately the case will be final.
He's not appearing means he might have received all the money.
My lord.
So therefore he's not interested. Let it
He is
go.
not to come in.
My lord.
That may be the reason.
My lord.
Despite notice, opposite party number 2. Despite service of notice, opposite party number 2 has not appealed. Opposite party number 2 is the complainant in the ICC case number so and so. देखो ये ICC case number 93 of 2005. 2005.
My lord.
138.
Yes, my lord.
This is of 2005. The petitioner is the petitioners. How many petitioners?
Here one petitioner.
Petitioner is the accused in this case. The prosecution was initiated by opposite party number 2 under section 138 Act on the allegation of division of check amounting to.
That is 13/8/2005, 27,66,123.
27 lakhs 66,000
123.
123. 123. The counsel for the petitioner submits that pursuant to the check was issued towards the security, and the petitioner has already made good the entire payment. The complaint case is pending since 2005. Despite notice, the opposite party number 2 has not appeared. It appears that the petitioner, the opposite party is number 2 is not appearing as the counsel for the petitioner submits that since the opposite party has already received the entire amount covering the check, entire received the money in entirety. Therefore, currency is not appearing in this matter. Taking into consideration the fact that the matter is pending since 2005, I'm of the considered view that to mediation center. The mediation mediation center coordinators fix a date and issue notice to all the party concerned. And after exploring the possibility of settlement, furnish a report by the date of hearing. Please the matter awaiting the report on.
I left that part security and back dues.
Counsel for the petitioner also submits that he would take the copy of this order and intimate the same to the opposite party number 2. You intimate, take the
Mine.
Communicate the present order to opposite party number 2.
It's interim order to.
3 interim order content. Yes.
190.
Please, Your Lordship. My Lordship, on behalf of Mr. Sahu. My Lordship, previously this court has issued notice against opposite party number 4 to 7. In the meantime, 4 is appeared. Opposite party number 4 is appeared. Yes, my Lordship. But none others are appears. So my Lordship may call for the status report from the registry whether the notice has been sufficient enough or not.
No, leave the matter on Thursday, indicating that name of Mr. Prakash Kumar Samant as the counsel for the opposite party number 4. He is appearing. He is appearing already.
Yes, my Lordship. My Lordship, there is opposite party number 5, 6, and 7 is also there.
Nobody is appearing for them. What is this matter?
My Lordship, it's a matter three five actually, 395 and 385.
395, my lord, question of criminal proceeding. And the petitioner number 1 having 4 criminal antecedent. Petitioner number 1 having 4 criminal antecedent, my lord.
My lordship, it's
No,
a
that
matter.
is, why, on what ground you want person?
My lordship, there is no TI parade was there. And my lordship, it's a matter of only 30,000 rupees only.
Maybe, but
Money has been recovered from the petitioner number 1, my lord.
you have implemented the investigating officer, officer in charge, so many people, complainant, and which Vibhuti Vishwal, victim, all victims.
What happened, my lord? In this case, 30,000 money which has been snatched by this petitioner, my lord, that has been recovered from this petitioner.
What is the stage?
Now the stage, my lord, regarding the trial, my lord, that instruction I have not.
What
I
is
have
the
to
stage
obtain.
of the?
My lordship, I have no instruction, my lordship. My lordship, I have to take instruction for that.
See, this matter since 2023, many hearing, hundreds of hearing has taken place.
My lordship, maybe a short date, maybe urgent this matter for.
What do you say? What do you say? You have no objection?
Yes, I have objection.
Then tell me what do you say? I want to dispose it up right now.
Only the petitioner was snatched away the money from the complainant as from their friends. But also,
You tell me whether you are ready, in fact ready or not.
yes, I am ready.
Don't waste time. Are you ready to argue?
It was recovered from the possession of the present petitioner.
See, that he has already said. Anything else?
There are full evidence available on record. Privacy.
Yes, madam. What do you say?
My lordship, Mr. Sahu is not available. For
It's better that why he's not prepared. I'll put it next week. I'll dismiss thereafter. Okay. Get ready and come. Next week we get no case on merits. Get ready and come.
20.
On the request of petitioner. Last opportunity given. May I refuse you? What time? 15th. We are waiting this of fresh back. Till 4 o'clock will do.
Yes, petitioner have filed this case for quashing of lawsuit.
Yes, sir.
And the cross of the matter is, my lord, the opposite part number 2 is the proprietor of Dora Construction Company lawsuit.
Yes.
He has taken a tunnel work from Afghan infrastructure, my lord, from 2014 to 2020, middle of the 2020 lawsuit.
Opposite party number 2.
Opposite part number 2 is the proprietor of the Dora Construction Company and working as the subcontractor of Afghan Infrastructure Limited lawsuit. Afghan Infrastructure Limited. Dora Construction, opposite part number 2 is the proprietor of Dora Construction Company lawsuit.
Dora Construction Company. Okay.
And the Dora Construction Company has taken a tunnel work of Afghan Infrastructure Limited at Jammu Kashmir lawsuit.
Okay.
And the deceased is the brother of the opposite part number 2, your lordship. And he is working under the Dora Construction Company. Deceased. And the opposite part number 2 lodged an affair in the on 17/3/2020 again before the Digapandi police station for commission of the 306 offense against the employee of Afghan Infrastructure Company lordship. And that has been ended in final form lordship. And final form is under annexure 1 series, that is 23. May I draw your attention of final form?
Yes.
Lodged by the
This
filed
matter
by
was
the
earlier heard by
yes,
me.
my lord.
Earlier heard by me.
And thereafter,
Yeah.
protest petition has been filed by the.
I'm sorry, my
I got in the lift. The lift itself got stuck. For almost 10 minutes, I was there stuck.
That's designed by you what to do. Yes. And this matter I heard.
Yes, well.
For I think the same matter, if I am not mistaken, where the money due was not recovered, therefore he died.
Therefore, they claim, my lords, their claim of suicide is that because money has not been paid, that is why he committed suicide. My lords, after 8 months, they were contractors under this company. Came back from Jammu and Kashmir during the COVID period. 8 months thereafter, my lords, he committed suicide, and an FIR was lodged after 7 months. Now, my lords, what happens? Then what happens in this case? After 7 months, he makes a bold allegation that because money was due, so he was under mental depression and he committed suicide. If that be so, my lords, there is no proximity to the.
There is no time declaration.
There is no time declaration, nothing,
Yes.
no letter.
How? 306.
My lord, the postmortem report.
Maybe.
The poison regarding the.
He might have taken poison. And in the life, there is a lot of stress.
May I permit to?
And then all the lawyers, those who are there from the court also, might have died by now because the clients never pay after this thing. If you don't pay, don't recover, you commit suicide.
My lord,
what is this?
The informant complainant as I may read the one.
Don't read.
My lord, the mu contract काम करते गत 2008 मसीहारू C class contract license ओडिशा रे कोनसी काम न पाइबारू.
And even he is not. His brother was working.
That's why.
His brother would have committed suicide. Something could have been done, you know.
से मु पैसा देलेनी मु 6/8/4/21 रे एडवोकेट लीगल नोटिस पठाइथिली किंतु कंपनी दायित्व थिबा जीएम एजीएम मध्ये मोर कोनसी बकेया पठाइले नै किबा एमपी वर्क ऑर्डर ईयर वाइज स्टेटमेंट इत्यादि मध्ये देले नै उक्त कंपनी रे मु सुडंग काम करी मु निज टंका विनियोग करिथिली कोरोना महामारी जो थिली जाक मोर परिवार
This is because of the stress in the corona time. Many things has happened. The people came under the stress, but no criminal case can be judgment reserved.
Obliged.
But it may be harsh case, emotionally and otherwise also drained out. Everybody is drained out those days.
Well,
that may be a reason for committee.
Well, then the FIR is 7 months after, even if there was some proximity, FIR
7 months.
Hostage mentally balance administrative.
Your lordship's own judgment is there. Priyanka Taporia versus State of Orissa.
Yes, I passed that.
Yes.
That was also very harsh.
That was also
very, very harsh.
Yes. This is
but
there.
With heavy heart, I had to do it, but yes, I did it.
Proximity is necessary.
Criminal cases such is not. That judgment you keep it.
No.
Yes. If you can give a timeline, then it would be better.
I'll give your lordships a timeline.
Tomorrow you give a timeline so that it will be easy for giving it.
Date chat, I'll give a timeline.
I'm for the open number 2. My presence will be open.
You are the brother.
Right.
Yes.
Obliged.
121.
Yes.
May I please, Your Lordship?
Yes, madam.
My lord, here in this case, here in this case, is a mother-in-law and the sister-in-law. They are challenging the framing of charge, my lord. And the marriage is already dissolved between the son and the informant, my lord. And there is a chance of settlement.
Send it.
My lord, my.
Yes, sir. I'll send it.
Charge was framed in the year 2023.
Maybe matrimonial dispute. The wife and husband separated. Right. They are the in-laws. Why to suffer?
They are in-laws.
So why these people? I know. What have you challenged?
Framing of charge.
Framing of
The
charge.
petitioner is agreed. The petitioners are agreed by the order dated 21/3/2023 passed by SDJ Parala Community in GR case number 146 of 2018, whereby charges against the petitioner have been framed for offences under section
294, 406, 498A, 506 and 34 of the IPC, read with 4 of the Dowry Prohibition Act.
Learned counsel for the petitioner submits that the marriage between the opposite party number 2 and the son of the
Petitioner number 1. Petitioner number 1.
1. No, 64. Jyotsna, petitioner number 1, Jyotsna.
Okay. Thank you.
Son, who is the husband?
Husband
is not as a party.
I tell me the name. Son of the petitioner number 1.
Yeah. Prasant Kumar Paikrai.
Prasant Kumar Paikrai, na?
Okay.
The marriage between the opposite party number 2 and the Prasant Kumar Paikrai, who is the son of the petitioner number 1, has already been dissolved. Mutual consent.
Or by ex party order.
By dissolved. And there is a chance of settlement being a matrimonial dispute. Hence, she seeks direction from the court to refer the matter to mediation center.
But there is a
mediation center.
There is an IA for the stay for the process.
Since the matter is referred to mediation center, and the further proceeding in the zone state till the exploration of takes place. Till the mediation takes place.
Yes.
Rest of the matter will
one
remain
compromise matter. If you not say both parties have come from 10th.
Okay.
One compromise. Right?
Yes. Item
130.
130. More. Yes. And present petition. The petitioner and the opposite parties are present in the court, are being represented by the respective counsel and identified by them. They have also filed their self-attested copies of self-attested photocopy of the opposite party has filed, not joint opposite party number 2. Filed an affidavit dated 13/5/2024 inter alia, that dispute, and the opposite party number 2, who is the informant of the victim, has filed an affidavit. I am of the considered view that subjecting the petitioner to trial would be a futile exercise, and therefore, in view of the settled principle of law and instituted by the Honorable Supreme in Gansing versus so subjecting the cannot be fruitful, as the prosecution cannot secure a conviction in the present case, and there is a big chance of conviction. In view thereof, the petition deserves merit. Accordingly, the cognizance order you have challenged, or what you have challenged?
Cognizance, 29/11/23.
The cognizance order of impugn